Yes. What is this? Application.
Lordship, may I permitted to mention one matter? WP LRT 122 of 2026, wide order dated 7th August.
What are you mentioning for? Intuition?
Tagging of the substitution appeal, because Lordship has
Main
already.
matter is direct.
Yes, you have
And-
already directed.
and-
May I have a lordship's leave to file the memorandum of
Obliged,
appeal
Lordship.
without the certified copy. Order passed on 17th, applied on 18th. And I intend to move it on Monday, my lord.
Yes.
My lord,
Monday
order,
দিয়ে দেবেন list.
my lord, order 41, rule 11.
My lord, order 41 rule. Of what? This is the matter. Application or?
Application.
Are you sure it's application? It's written application there?
Yes.
You come prepared, ma'am. Yes.
Let them, I have a list, matter on the list, matter
First.
on the list mentioning.
Which has a chance of refusal.
Absolutely. Which has absolutely.
Yes, yes. Got it.
My lord, two application. One is
Application handle. Yes, lodging, obviously. Yes, sir. Now
Sir,
you're-
item number 59 of your tribunal hearing. Well, I mentioned on 8th of January, Lordship told me to wait. Lordship will put a date for tribunal hearing. This is Millard, a BT road land. I have on all through. Millard, I have Millard, my Lordship called twice, respondent was not
Difficulty,
there.
Mr. Coach, we are frankly telling you, we have more headings in our list than number of days in the week.
Absolutely.
That is the difficulty we are
That is the
facing. That's an
problem, Millard,
actual
of the
difficulty.
judge, Millard, litigation ratio in our country. That's Millard, not,
Yes,
Millard, everyone writes Millard, but no one has. the
litigation
solution.
ratio and vis-a-vis individual judges also. I mean, it's very difficult because we have
If
clubbed it
any
under
date
hearing.
Lordship Millard takes up the tribunal hearing, Millard, that Millard may sort up because other side twice have not, Lordship has called twice, gave them last chance, peremptory. Still they don't appear. Millard, in fact, Lordship's order is there.
Yeah, on-
একবার জজ সাহেবকে দিন তো।
বলছি, না, না, you need not look at পরের, ইয়েতে, বৃহস্পতিবার, করে রাখুন।
একটু জজ সাহেবকে এটা দেবেন।
Tribunal hearing গুলো আগে দেবেন, তারপর intra-court hearing.
Other side
Serial
appear.
application. Next Thursday, we are proposing to put the tribunal applications and intra-court appeals first before civil.
One
Very
application.
Next Thursday, we'll do it.
Great.
One application.
Much.
Applicants. Yes, Colin.
Item number 1.
Yes, Mr.
My lord, may I pray for just 10 minutes of your lordship's time, my lord? I'm stuck, my lord, in the hospital. I'm just on my way.
Oh.
10 minutes, my lord, I'll be there before your lordship.
So, Banerjee, any difficulty?
My lord, one matter is going on, my lord, before my lord Justice Shampa Shawkas.
A matter, Mr. Banerjee's matter is going on in a different court, Mr. Chatterjee, then we'll.
I'm there in that matter. I'm there also, my lord.
He's leaving
because
me,
Mr.
and my lord, Mr. Mukherjee is there, my lord, as our
So
leader.
then that
He's
has to get split president. Then Mr. Chatterjee, we are adjourning for the day. What can we do?
My lord, I just indicate since Mr. Chatterjee is there. This is from my lord, suit, my lord, a decree, my lord, passed, rejecting my lord the prayer for divorce. My lord, it was my lord wife's my lord suit for divorce. I am the my lord husband. Husband is my lord agreeable, my lord, to divorce, but not on the allegations, naturally. So, my lord, if Mr. Chatterjee takes instruction,
Difficulty, Mr. Banerjee, in a matrimonial matter.
No,
is-
I'm
can-
absolutely, my lord, ad idem,
23 is not per se applicable.
not per se.
We have to relegate it to the trial court.
No,
That's
it's
the
a-
last petition.
No,
That's
my
it.
lord, your lordship, on the last occasion, if your lordship remembers,
Yes.
Lord, we had said that about irretrievable breakdown of marriage, and that
We'll
becomes
record.
cruelty. Yes, my lord.
Well,
And
Mr.
then grants
Chatterjee,
divorce,
we get the clue. Yes.
my lord.
So
My lord.
if you put in some affidavit, you think over it, Mr. Banerjee, if you can put in some affidavit,
and
take what you are saying.
Then my lord, he lives abroad. My lord,
Whatever,
can-
whatever. This matter.
This
So we'll put it after a week, and you take whatever instruction, and if you file a very short affidavit indicating what you exactly say,
yes.
then we can treat that to be irretrievable breakdown as
This irretrievable breaking down of marriage, my lord, is possibly a subject matter of Article 142. My lord, there lies the
No,
difficulty.
no, there's
no
one
longer,
judgment.
no longer. Not in our court. Not in our court till the judgments we are passing are set aside by this. We are waiting for that period when it will be set aside. But before that, we'll do whatever we really.
That amounts to mental cruelty.
Yes. No, the setting aside of our judgments.
No, no, no. Yes, for the person who got the
Some
degree, it is,
extent,
my lord.
yes. No, but we don't personally. So we are
Well.
putting it after 1 week will suffice.
Yes, absolutely, my lord. There's
No,
no
not
problem.
for you. Mr. Chatterjee's client lives. Mr. Banerjee's client lives abroad.
Well, Mr. Banerjee's every client lives abroad. He knows well, my lord.
But he lives here. That is the difficulty. He's having to face the court.
I'll tell your lordship, my lord, later about Mr. Banerjee's.
ও এখন ইনস্ট্রাকশনে ব্যস্ত।
2 weeks. Well, it transpires from the submissions of learned counsel for the parties that there is a scope of amicable resolution in the matter. Push up next para. Accordingly, let the matter be listed under the same heading on September 3, 2026. 3rd September. Yeah. 3rd September, sir. Yeah.
Grateful to Lacho.
Great.
But there's one thing, Milord. Looks are always deceptive, Milord, about Mr. Banerjee. Your Lordship said he's academic. It's deceptive.
যাকে দেখাই যাচ্ছে না সে যাকে দেখা যাচ্ছে তাকে ডিসেপ্ট
We'll consider that in an appropriate.
So grateful, Milord.
Mr. Saptanshu Basu is waiting to do a matter and you are disturbing him. I mean,
Milord, Mr. Basu is always waiting, Milord. He'll wait.
yes.
Yes.
Thank you, Mr. Chakravarti. Next one.
Item number 3.
First hearing what, Mr. Basu?
I'll not trouble your lordship much.
No question.
Well, can you recall, on the other day the matter was taken up for hearing.
Yes.
I say, my lord, there is chance of compromise. Why I have said that? Let me repeat that. A suit for declaration that they are entitled to a share of 2/7 of the entire property. When they approach your lord, the court, in the meantime, 90% construction made
By you.
without violation of any interim order.
That obviously.
Now, my lord, an order of injunction has been passed. Against that, I am before my lord. My submission was on that date that I am going not disputing your claim for the time being.
Substantial construction has been made. That is
90% construction made, relying on 2008-11 SCC page 1. I can argue, but I say, what do you want? You are entitled to some share. It is your claim. For the time being, I am accepting the claim. Say in which portion you want. If it is constructed, your land value is there. Constructed portion, I am giving.
compensate.
No, my lord, I will able to understand what they are asking for. They send the SMS in the night at 10. Let it be hard from Mr. Bhattacharya what they want.
What do you want? None of them are sure what they.
Let him explain to
My lord, we brought the share of
2/7.
2/7 share.
It's very complicated. We won't hear you for long.
No, it's 2/7 share and
2/7 share. That what has been told by
In a plain case.
in the plain case. And the constructed area, the market price we have, they wanted us to buy out our share. We have placed a proposal in terms of the constructed area as per the market rate, to which we have not received any reply yet.
You want to
No,
buy
no.
out the constructed?
No,
portion?
How?
They want to buy out our share.
They want to buy out
The land share.
land share regarding that portion where they are constructing.
Yes. Now, since the construction has already been made,
Exactly, it's pragmatic. It's a pragmatic view. 90% construction. Very few courts will direct demolition of that at the end of the day.
We may
What
Take a
mediation?
chance.
This is the mediation. What do you want? I
So we love sending matters to mediation. We would say immediately send. An indication is given, you send it to mediation. We are happy.
I have a quarrel with Justice Bhattacharya, who was the mediator in a matter by the Supreme Court.
Oh. That's
No,
what
what- Seeing Mr.
not
Justice
his
Bhatt-
field.
Well, I am just looking at Mr. Justice Bhattacharya is in mediation.
What can you do?
No, he said that.
Your
বলছিস আমি কি করব?
your
My name has been mentioned.
Calcutta people are doing that. To you.
No, outsider, Justice Padriwala. বলে আমি কি করবো? আমাকে নাম দিয়ে পাঠিয়ে দিয়েছে।
So should we send it to mediation?
But don't.
There
This
are
is.
skilled mediators also.
I don't prompt me
Not that
to
you don't
open my
the
mouth.
skill of the mediators.
No, not necessary. If the court cannot do it, none can do it.
Court cannot force you. I mean, court can
Not force.
negotiate
They
for
cannot
you.
also force.
They can negotiate. Help you negotiate.
I am opening my offer clearly before my lord.
Take a call on this, Mr. Bhattacharya. Come back.
What they want,
We think that will be reasonable. You are putting it as to be mentioned. Then.
let him say what they want.
এটা করে বলতে হবে কতদিন সময় লাগবে।
আরে আজকেই কোনো তো মক্কেল আছে, আজকেই করে দে।
হ্যাঁ, আজকে
Do it today. Do it. We'll keep it next week. Keep it.
Monday.
Learned senior counsel appearing for the appellant submits that the appellants have already made substantial construction, comma, which is almost 90% complete, comma, on a particular portion of the suit property. Full stop. It is submitted that since the respondent seeks 2/7 share in the property, comma, the appellants may look at compensating the respondent to the extent of the share of the respondent in the land on which the construction is being made. Full stop. Next para. At this comma, learned counsel for the respondent submits that in principle there may be an attempt at reconciliation. Full stop. In order to ascertain the terms of such reconciliation, comma, the matter is adjourned till August 27, 2026, when the matter shall be listed under the same heading. Now, let it remain in the hearing.
Yes,
If
yes.
you don't agree, then we'll hear out the
This is my point. I see that I have argued my matter.
equity and
Great. No comment. But such an injunction, the gentleman is not coming to court. We cannot get our treat. This is injustice to us. This is injustice to us. আসছে না court এ। Great, put to bed.
In this matter, my lord, Mr. Meghnad Datta appeared for the appeal, my lord. Due to his brain surgery, my lord, he's not come to court. My lord. Brain surgery, my lord. Meghnad Datta. Vasudev Patra advocate. Meghnad Datta leading, my lord.
who was appearing?
Mr. Meghnad Datta, my lord. Senior counsel. my lord.
Order sheet to him.
Yes, my lord. Order name was there, my lord.
So Meghnad Datta was appearing. So what should you do? Tell us.
No.
Hearing matter, second matter.
My lord,
How long will it take to recover?
15 days time, my lord, because my lord,
Then you are suffering an injunction.
no, there is no any injunction. There is no any.
Then it
No,
goes out of the list.
no any injunction is
See,
there.
Mr. Mondal, we are being very candid. We don't want to sound cruel, but definitely people have
7 days, my lord, 7 days online there.
either we make alternative arrangement, which we did when we were advocates. If we had difficulty, we requested the junior to make alternative arrangement. You make alternative arrangement, or we put it out of the list. We cannot hold the list and not include other matters because of
7 days time, my lord. 7 days.
7 days. Definitely is reasonable. Mr. Mitra, we are adjourning for 7 days. An adjournment is sought on the ground of ailment of learned counsel leading the appellants. First up, next para. Accordingly, the matter is adjourned till August 27, 2026. First up, in the event learned counsel remains indisposed on the said date as well, comma, the appellants are requested to make alternative arrangements to ensure that the matter is heard on the next day.
Lord, I appear for the appellate. Very short matter. 7 brothers inherit 1/7 undivided share of the ancestral property.
Mr. Banerjee, the respondent has not been appearing at any.
Not at all.
Notices were served. Yes.
In fact, after last day's order, where my lord was pleased to record that it is made clear that in the event respondents remain unrepresented on the next occasion, when the appeal is called on for hearing, ex parte order may be passed against the respondent.
Service return report say no person at such address. Service proper service. The service return report regarding the notice of the appeal. It was we find the office report to say that no such person in the address.
So
the respondents could not be properly served.
So one of the issues is we couldn't serve them even at the trial stage. Substituted service was affected. They were not there. So now that is the issue. They are not there since the trial court.
At the same address.
At the same address.
The trial court finally decided the suit on the basis
Ex parte against me
by accepting that service. I mean,
yes.
Was
substituted service was affected and accepting that service.
We give you 1 week's time, Mr. Banerjee. We appreciate what this. I mean, you are suffering, but we'll advert to this previous order, but we'll direct it as a last chance. We'll direct you to effect substituted service.
Fine.
Do it immediately in some newspapers in the area.
Would it please my lord to keep it then Thursday week because I'm not in Calcutta?
It will take some time. At the time of call, comma, the appellant is represented through counsel, comma, although none appears for the respondents. First up, we find that the respondents have consistently been absent. First up, however, comma, an office report dated May 19, 2026 indicates that the service of notice of the appeal could not be effected properly on any of the respondents, and the uh, attempted services returned with the endorsement no such person in the address. Full stop. Next para. Thus, comma, although we indicated in our last order dated August 13, 2026, that in the absence of the respondents, comma, the court may proceed ex parte, comma, as a last chance to the respondents to appear and contest the appeal, comma, we direct the appellant to effect substituted service by publication in 2 daily newspapers, comma, one in Bengali vernacular and the other in English, comma, having moderate circulation in the area of the last known addresses of the respondents, and file an affidavit of service to that effect on the returnable date. Full stop. Let the matter be listed next on September 3, 2026 for hearing.
Much obliged.
I'm for the appellant.
For the respondent wife.
Very
Respondent husband presumably because it's appeal by the wife.
Mr.
But
Banerjee
to-
is doing so many matters, he's now confused.
Your
So,
Lordship.
But to relieve my learned senior friend as well as your lordships, I have received the email today from my client saying she wants to withdraw the appeal.
you have challenged the divorce decree.
Divorce decree.
ও পরে আর দিতে হবে না সব ও-
It's being withdrawn. This is the written.
It's a very sarcastic email.
It's very sarcastic. It seemed like an aspersion on me also. So I contacted. She says, no. Actually, I have talked with the husband. Now we have got the matter settled between us. I said, okay.
Very well. Learned counsel for the appellant submits that the appellant wife no longer wishes to proceed with the appeal and files the printout of an email written by the appellant to learned counsel for the appellant in that regard. Full stop. The said printout be kept on record. Full stop. In view of the above submission, FAT 193 of 2025 is dismissed for non-prosecution without any orders to costs. Interim order is, if any, stands vacant.
Miller, just one. Just. It has been sent to the advocate on record, not to me.
যেখানে কাউন্সিল বলেছি না কাউন্সিল ফর দি অ্যাডভোকেট অন রেকর্ড ফর দি ওই email written by the appellant to the learned advocate on record for the.
My lord, only one indulgence, my lord. This appeal is being withdrawn, but there are other proceedings, my lord.
We won't comment on that.
Yes.
We cannot.
And I also don't have any instruction to comment.
So those won't be affected. We are
Those
not
won't.
saying anything else. This appeal is before us. We are just saying they are not proceeding. The effect of this you may argue in the other matter.
Grateful.
We cannot make any comment either way on
Either
that.
way
That
of
will
my
prejudice either you or them.
Item number 7.
No paperwork has been served.
I have wrote a letter, my lord, already.
No, why didn't you take it from the department? They are
Yes.
filed in the department.
There are 6 paper already filed in the department, my lord.
You have to take it from the
Yes.
department. Why should they give you copy?
But I am already wrote letter to Baba
Written
Tao.
letter to whom?
বুঝলাম
You have to take it from the department, sir. It's not a good ground for adjournment.
I shall
Take it immediately today. Send
May
your
I,
clerk.
may I give a copy?
Please do it. Yes, you can do it. Give a copy.
Then, my lord, kindly record it there. I have.
Do you have an extra copy?
Yes, I have an extra copy, my lord.
Give it. We'll start the hearing. You should have done this earlier. You should have taken it from the department. We don't understand why you didn't.
Sorry, my lord. I shall not understand.
But this is not a good ground for adjournment because if you start adjourning hearing matters, next matters will may flop. The people are not ready in the last hearing matters. We'll start hearing then. You do what you want. You have a copy of the memorandum and other things. So you know what is the appeal about.
No, I have received the copy from my London friend. Then I shall proceed with that.
You are ready.
No, today not, my lord.
Learned counsel for the we are adjourning for the day.
Adjourn.
Learned counsel for the respondent submits that despite having
yes, my
written
lord.
letters to the appellant's advocate, no copy of the paper books were served on a bit softer, please.
Already Bhogalat now filed.
Please softer.
Stop.
You're in a court on him. Full stop. Next para. However, comma, we do not find any reason in such submission, comma, since it was always open to the respondent's advocate to receive copies of paper books filed in the department. First up, be that as it may, comma, learned counsel for the appellant, comma, in his usual graciousness, comma, hands over a copy of the paper book to his counterpart appearing for the respondent here and now. First up, accordingly, to enable the respondent to come prepared in the matter, the same is adjourned till August 27, 2026. Please come next week. Next session.
My lord, much obliged.
Item number 8.
This matter I have a petition.
Yes.
This is the second contempt application. This is the second
Mediation
contempt.
has failed.
Second, yes. Petition, I am for the petitioner. Second contempt application, this one. Because earlier there was an order, if your lord
Contempt.
find,
This is a first appeal.
no, this is a contempt.
Which matter are you appealing in?
Item
8 is an appeal
item
hearing.
8.
Appeal hearing. What are the name of your parties?
Sagiram.
No, it's a different matter.
Different matter.
Some other list maybe, somebody else's list.
Sagiram.
You have a copy of the list?
Checked up. Have you seen today's list or some other day's list?
It is there in the list in number 8.
No, this is an
No, not
entirely different matter. Nothing to do with any Sagiram.
Sagiram was there. I'm shocked. Oh. It came on the online, but this today's list in the morning, I think. We got it on the online. That is the
Oh,
problem.
no, that sometimes differs with it.
Then we'll take up. We'll take up.
None appears for the parties at the time of call. Full stop. Next para. As a last chance to the appellant to argue the appeal, the same is adjourned till August 27, 2026. Full stop. It is made clear that in the event the appellant remains unrepresented on the returnable date, comma, ex parte orders may be passed in the absence of the appellant.
Item number 9.
Yes.
For the appellant, my lordship, I'm praying for notice to wake.
Refused. Start the matter.
My lordship, my
Food safety and standard.
my lordship, my yes.
You are still insisting on that prayer?
No.
Her prayer was refused right now. She has to start the matter.
My lord, I'm only, my lord, praying if it could be taken up on any other day.
No. Why?
My lord, Mr.
You are appearing, then no question.
No, my lord, Mr. Moinak Bose, my lord.
What you are there, you started. We won't grant time.
My lord, can it
Giving
be?
you 5 minutes passover to prepare yourself.
My lord, only one indulgence, my lord. If you
No
lordship, I am not
You're
on.
very equal on that.
My lord, only one indulgence, my lord. If my lord, if I start today, lordship, I will start on the next date, my lord. My lord, only one issue is
Don't give you
lordship.
that indulgence.
My lord,
Complete the hearing
my lord,
today
actually,
itself.
the
Food safety act,
difficulties
how
is,
long can
my lord, actually, my entire case preparation is on my tab, my lord. My lord, yesterday, my lord, I lost this tab, my lord.
My
That
lord,
is
can it be
only
taken up?
difficult.
My lord, otherwise, I'm averse to, my lord, taking time.
Ready, my lord. If you my learned
No, you are averse. That's why you are insisting
But
on
on the
my
next
lord,
day,
there's a leader, my lord, in the matter. There's a request. If it can be taken up
that. It
tomorrow.
goes out of the dismissal.
Tomorrow.
We cannot retain matters in it. We cannot. We were refusing people regarding appeal hearing inclusion in the list, Mr. Lakman. We cannot go on granting agenda.
No, that, my lord, I
No, Mr. Lakman. Let's start it. We are passing it over for some time. Let us dismiss other matters in the meantime and then we'll come back.
My lord, instructions are that Mr. Bose will argue. Can I just have a word with my advocate on
Your
record?
problem, Mr. Lakman, your client's problem. If he's not there, you start the matter. We are not granting agenda. You don't even have the paper book. You have your tab.
My lord, there was an order by your lordship that, my lord, the appeal would be heard on the basis of documents which already form part of records in the stay application.
Let us start it.
So there was no direction, my lord, to make a paper book.
Start the matter. No time.
My lord, would your lordship in that case pass it to my lord?
Passover. Passover.
only lordship, my intention, lordship, if my learned friend start, my lord, on the next, which
You prepare yourself, whatever papers you have. You take papers.
only my entire case preparation is on my tab, my lord. Yesterday, my lord, I lost my tab, my lord.
Can't help you. No time. Yes.
Item 10, I appear for the.
Your lordship, I appear on behalf of the appellant. As per the last direction of this honorable court, I have prepared a compilation of the documents. The paper book formality was dispensed with
It was
the beginning.
substantially by Justice Supratik Bhattacharya.
Not
Not
substantially.
substantially.
What has part heard?
Not even mark. Only thing I'll just apprise your lordship. The property concerned in this
You
appeal.
have to re-argue the matter because Justice Day was not there.
Yes, I'm not re-arguing lordship. I'm
No, you
just,
have to
we
because
will.
you have to
We
just
will.
in a nutshell.
Yes, my lord. My lord's only thing is the property today the appeal is against an order passed on 39 Rule 4, vacating the order of 3912.
At your instance, it was vacated.
And my instance was vacated. Now, lordship, the 3912 application essentially sought a status quo on the property.
That's still pending.
No, lordship. Now that is all. That is also pending.
Injunction
Yes,
application is pending.
3912 is also pending.
3912 is
Only
pending.
thing, lordship, is the same property. There's a status quo order by the Honorable Apex Court based on a litigation between the other branches of the family. So the
But the difficulty
status quo remains.
that
So,
is
lordship,
that will be a
that's-
part of your arguments.
Yes, I'm just saying. So the status quo
Part of
remains.
your arguments, but we cannot because they may argue that
Absolutely.
they won't be.
They will have
They're
an
not willing to
independent-
be dependent on.
They
Suppose
might.
that goes tomorrow.
Yes, my lord.
Then
They
they'll
might.
be at the mercy of that matter.
They might.
Whatever.
They might.
So
We are
they
not a
might-
party to that
Yes.
matter as well.
So that's also a valid
Even
argument.
we are not a party to that matter. We are also filing an
You
intervention.
are not bound.
We are a developer. We are also filing an intervention. The other respondents are a party there.
You are for respondent number. You are
529.
Have you
Respond.
filed a formal application for intervention?
No, no. Here I am. Here I am a
Oh, you're a party.
Here I am. That Supreme
That-
Court,
that-
Apex Court, I am not a party.
Ma'am, start the matter. Yes.
Okay.
Very good. We like this attitude. Thank you. Yes, start the matter.
Your Lordship, I'm referring to the compilation of the documents that I filed.
This one.
Yes, Your Lordship.
Yes.
I have annexed firstly the family tree in order
Please take
to.
your seat.
Yes.
Yes. Yes.
I have annexed the family tree of.
They have a copy of this.
Yes, I have duly served the copy on there. If you want, I can.
Right. Family tree. Yes.
Soft copy to party digital.
What is the matter about? Just give us a brief.
Your Lordship, this is a matter about a property situated in Iqbalpur Lane.
No, the suit is for.
The suit is for declaration of title and for declaring certain deeds null and void, which we have challenged as.
You purportedly executed those deeds in his favor.
No, Your Lordship. If I may just place the facts on
Very
record. This suit property originally belonged to Miss Mary Winfred Earle. This was during the British era. She had three children: Clarence Broderick Earle, Redmond Percival Morris Earle, Neville William Earle. Miss Mary died testate.
They were Christians by faith.
They were Christians by faith. Now, Miss Mary Winfred Earle, she executed a will in 1949 and she died testate in 1950. Her first son, Clarence Broderick Earle, predeceased her, and before predeceasing, he had a wife and a daughter out of that wedlock. The wife's name was Elizabeth Frances Earle, and the daughter's name was Anastasia Maureen Earle. Later on, after marriage, it became Somerset. Thereafter, Redmond Percival Morris Earle, he was he died, and he was the executor of the will of Mary Winfred Earle during his lifetime. He had obtained probate of the will of Miss Mary Winfred Earle. As per the will, certain properties, there were a lot of properties which were demarcated and distributed between the two surviving sons, that is Redmond Percival Morris Earle and Neville William Earle. If I may take your Lordship to the will of Mary Winfred Earle, at page number 1 of the compilation.
Her will, Mary gave the property to whom?
Mary gave the subject property to Neville.
Only to Neville.
Yes, your Lordship. If I may take your Lordships to the will of Mary Winfred Earle.
Now, let us proceed first, understand the facts. Now,
Definitely.
Mary gave this will to Neville. She
Yes.
died, probate was obtained. So, therefore, if probate was obtained, then Neville would become the owner of that property. Mary's
Yes, your
property.
Lordship. Yes, Lordship.
So, you said property was given to Redmond as well as Neville or something like that?
There were 8 properties. 4 were given to Redmond solely and 4 to Neville.
Mary's properties were given equally to
Equally
and
distributed, but
Neville.
there were no shares in each other's properties. Redmond was given
Exclusive
specific
properties.
exclusive
Very
properties,
good.
your Lordship.
So, regarding Redmond also left a will.
Redmond died intestate.
All right, very good.
Redmond's properties are not at question.
So,
over.
Neville's properties are only under dispute here.
Yes, your Lordship.
Very good.
One of the properties.
You claim through Neville.
Yes.
Achha.
Then? Yes. So now Neville William Earl, after obtaining the probate of Miss Mary Winfred Earl's will, he became the owner of 27 Iqbalpur Lane. Thereafter, he purportedly executed a will. However, that will was never probated. No letters of administration was obtained for that effect, and thereafter, in effect, that will was not executed as per the terms. So, our case over here is that after the death of Mr. Neville William Earl, his will did not have any effect, and therefore it would go to the properties which he had during his lifetime would go to the next of his blood relatives, namely Anastasia Maureen Earl's children, David Christopher Somerset and Margaret Annette Gardiner.
All right.
So
They were his only heirs at the time of his demise.
the only blood relatives, yes, Your Lordship.
All right. Oh. She's doing well, Mr. Banerjee. Let her complete the genealogical table. Yes. What about Raymond's heirs? Redmond's heirs?
Redmond during his lifetime had married a widow, and he had children from his erstwhile. The widow had children from her erstwhile marriage.
These are those children.
These are those children.
So David and Margaret were the only blood relations of Neville.
Yes.
Well, then proceed after that.
So after Neville's death, Rosemary Somerset, after David's death, inherited her husband's share. In the bottom of the genealogical table, Your Lordship, left bottom.
All right.
David Christopher Somerset and Margaret Annette Gardiner were the two children of Anastasia Maureen Earl Somerset.
You are Rosemary and Margaret.
Yes, Your Lordship. I am Rosemary and Margaret.
And what is their case?
Their case, I'm just putting it in a nutshell. Neville William Earl, the will which he had executed, which was not probated till date.
They rely on that.
They rely on that.
It was never probated at all.
No, Your Lordship. That is an admitted position. Sati Bhushan Dotto, the executor of Neville William Earl's will, he had resigned from his executorship. Thereafter, Herbert Cyril Lloyd, he was one of the legatees of Neville William Earl's will. He had applied for a letters of administration. He had preferred an application for letters of administration. However, that was dismissed for default during his lifetime, and he took no steps whatsoever to restore the same. Now, after Herbert died, he died leaving behind a will, and via that will, he appointed Mr. Augustine Robert de Cruz as the executor to his will. And in that will, he specified that all my properties that are with me till date shall stand transferred upon my death to Augustine Robert de Cruz, including those which had been transferred to him via Neville William Earl, which from the will of Neville William Earl, which was never probated, which was never obtained letters of administration as well. As per the Indian Succession Act, unless and until which has now been gone away with, but at that time when it was effective, as per section 213, the probate or the letters of administration had to be obtained in order to establish the rights as per the will. Without establishing the rights from the will, he could not have given of the properties to Mr. Augustine.
Yes.
Now, Mr. Augustine Robert de Cruz, he preferred two applications before the competent court. First, OS 4 of 1981, regarding the probate for Herbert Cyril Lloyd's will. Simultaneously, he also preferred an application for letters of administration of Neville William Earl's will. First, he obtained the probate of Herbert Cyril Lloyd's will.
You don't have any problem with that, Herbert's like.
We have a problem with the derivation of title from an unprobated and
that is Neville's part.
Yes.
So you don't have any problem regarding the probate obtained for Herbert's own property.
Herbert's own properties are not at
So the
contest.
Neville part, you are agreed because he
Yes,
filed
Your
the letters of administration.
Yes, Your
That has been granted.
Yes, Your Lordship.
Granted.
Yes.
Did you challenge the letters of administration at any point of time?
No, Your Lordship, we didn't.
Say that does not create any title.
Yes,
The
Your
succession court cannot create title.
Yes, Your Lordship.
That is your defense.
Succession code does not create the title
or cannot decide that.
yes, it will merely administer whether the will is valid or not.
So,
Yes, yes, Your Lordship.
very good. So therefore, then what happened? You filed this title suit on the strength of your inheritance from through people of Neville's property.
If I may just elaborate a bit more. Augustine Robert de Cruz, when he ordered that, when he obtained that order of letters of administration of Neville William Earl's will by a 2002 order in OS 5 of 1981, on that strength, that was challenged by some third parties before the revocation court, and that was also in appeal before this honorable High Court.
Revocation was dismissed against that appeal preferred.
Yes, appeal was sought.
Then
And from there, the interim order arose, which was against Augustine legal heirs, and which my learned friend has just specified that the apex court has also upheld the same, which is pending and subsisting.
Then what happened?
So after Augustine's death in 2012, while the litigations were pending, the legal heirs of Augustine, they executed one deed of agreement, purported deed of agreement, notarized deed of agreement, saying that after the death of Augustine Robert de Cruz, all the properties inherited by Augustine Robert de Cruz, which specified specifically of Neville William Earl's properties, that were also inherited by us in 4 equal shares by 4 people, the wife and 3 children of Augustine Robert de Cruz. On that strength, they have executed a development agreement with respondent number 5 to 9. Respondents 1 to 4 are the legal heirs of Augustine Robert de Cruz. Respondents 5 to 9 are the developers.
Yes.
Respondents 1 to 4 executed a development agreement with respondents number 5 to 9 on the strength of that legal heirship, and we, being the owners, we have challenged that after the death of Mr. Herbert, without obtaining any sort of letters of administration, he could not have any right over the same. This belongs to us. This has been obtained fraudulently. This deed is not valid in the eyes of law, and hence we had filed a suit before the learned court below.
Right.
Over there.
So in that suit, you claimed your title, declaration of your title, as well as challenged the development agreement.
Yes.
Good. Then in that you got an injunction.
In that we obtained an ex parte ad interim injunction.
Now.
That has been vacated now.
But the injunction application has been kept pending.
The injunction.
What ground was it vacated primarily?
On the ground of.
And after this, Mr. Banerjee may resume if you want. But you give us the ground.
The ground was for. Just a second, Your Lordship.
Take your time. Look up and tell us. Primarily on what ground?
Suppression of
material fact.
Suppression of
material fact being that Neville's will and all.
Yes.
All those things.
However, we had specifically shown it to the learned court below, and that has been recorded in the injunction order as well. That we had shown the development agreement. The development agreement contains certain recitals about Neville's will, Augustine's letters of administration order, and we had disclosed every material fact. Thereafter also the mini trial was conducted and an injunction was vacated, and 3912 is still pending.
Continue now. Whoever wants to argue.
Mr. Banerjee, please.
Very well argued. What is your name, please?
Ms. Divya Agarwal.
Thank you, Ms. Agarwal. Thank you very much. Yes, Mr. Banerjee, please take.
I'm really thankful to my learned junior.
She argued very well.
And Milord, she is well equipped with the facts. Now, Milord, I filed a suit, Milord, for declaration and injunction. Milord, I got the injunction. They filed an order 39 rule 4. Milord, the principal ground was that, Milord, I suppressed a material fact, which, Milord, according to them is material. The fact that, Milord, our, Milord, mother, Milord, had participated once, Milord, in the proceeding for, Milord, letter of administration, Milord, which was filed by Augustine in respect of Neville's will.
Your stand will be that this fact was not disclosed, but this is not a material fact.
Correct. And Milord, this was not suppression because Milord, question of suppression arises when Milord, I know the fact. Milord, my mother participated. Milord, I say that Milord, that was not known to us. It has nobody. It has been
not know the entire thing, the will and everything.
Milord, this Milord we came to know later on. But my lord, that my mother participated, my lord, there is no document to show that, my lord, we as individuals, my lord, know that. So, my lord, and knowledge is, my lord, thrust on us.
You had knowledge about the will and the proceedings. Mother's participation was not known.
Letter of administration proceeding, mother's participation in the letter of administration, my lord, because
You disclosed up to what you knew.
yes,
Neville's will.
yes, yes,
That has been disclosed
yes,
in
yes,
the
yes, yes.
All right.
Yes.
Very
And in the development agreement also, my participation was somewhere, my lord, recorded. My lord, when I challenged the development agreement, their case was that, my lord, I was supposed to know that I was supposed to go through the entire development agreement, the recital part of it, and I was supposed to know that I
But
did
you
not.
challenge the development agreement within limitation.
Yes, yes. My lord,
You have
from
challenged
the
that.
knowledge, yes. And my lord, if that cannot constitute suppression in any way of the matter, because my lord, if that is there in the recital of the development agreement, that's a form, my lord, a part of the record itself.
And you are challenging that itself.
Correct. So, my lord, this is what is, my lord, the matter all about. We say that, my lord, Augustine could not have got anything. My lord, today, my lord, our suit is against Angelo, my lord, on the right hand side at the bottom. Angelo, Rosalind, and Cabrini. My lord, they could not have, my lord, got a better title than what, my lord, Augustine could have had. Augustine could not have anything, my lord, better than what Herbert could have had. Herbert never had, my lord, Neville's estate in his hand. So, my lord, Neville's estate, my lord, that, my lord, percolated to, my lord, his legal heirs, my lord, through, my lord, intestate succession. Well, that's our, my lord, plain case. My lord, I need not, my lord, trouble your lordship, my lord, anymore. My lord, if my learned friends, my lord, show any law point, my lord, I will, my lord, revert to that. My lord, that's my simple case.
Lordship, I here am for the defendant numbers 5 to 9. I am the
Developers.
developer who stepped in, purchased the property from the heirs of
1 to 4 have not been contested. It was your 39-4.
it was
1/4.
both 39-4. Two of us filed 39-4
Both
because
them
I
and
was the most affected party.
Obvious.
I have developed
39-4 was filed by all of you,
Both.
all the respondents
Yes,
together.
yes.
One.
No, separate.
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 Very.
Lordship, my stand
Yours has
because
been allowed. Both have been allowed.
both have been allowed. Lordship, in short, there are two things. One, Lordship,
But the culprit will come to you last. You have done the mischief, so you take a seat till we call upon you. Yes.
my lords, what has been pleaded in the 3912 application is completely contrary to not even the records, but even the submission made currently. Because in their 3912, they have pleaded that the property of Maurice Earl, the subject property, which today has been admitted came only to Neville, was actually owned by both. This is a pleading in their 39.
Redmond and Neville.
Yes, my lords.
That is their pleading.
That is their pleading. Now, Lordship, thereafter, this entire transaction has happened in the year, Lordship, they have approached in the year 2025, whereas this entire transaction has happened way back in the year 1980s. 2001, the revocation case got dismissed. So they have said that I was living in London. I come up suddenly, I gain knowledge, the usual pleadings have come up today. What we tried to impress before the court is that there was no urgency to give an ex parte ad interim order. This is one of the reasons why we did not even press for a hearing and a dismissal of the injunction application. We said that can be heard, but an ex parte behind my back by a litigant who's approached after so many years without any justification of the delay, and this is their family, my lords.
The injunction was regarding transfer or construction?
Injunction was no third party rights, status quo sort of, my lords. I'll read that order for you.
Also construction covered.
My construction is over, my lords.
So
My
transfer,
construction is
transfer.
over. I have made it. It is part of my written notes. It's part of my
You are a
application.
developer.
I'm a developer.
The ground in 39-4 must be that you are developing the property.
I have developed. People have already entered. Now,
entered, they have entered.
a few of them have already got their conveyance deed registered, and a couple of them were at that point of time.
But these facts which are disclosed even in your 39-4, these also constitute urgency.
These constitute, my lord.
Urgency. You are a developer. You
Yes,
are
ma'am.
transferring properties. By
Yes,
definition, you are there to transfer properties.
Yes, ma'am.
After development.
The only thing that we
That
were
itself
contesting
comprises the urgency.
No, Lordship, it is already there. But the thing is, the pleadings are absolutely contrary to the records, which I get to see.
What is the contrariness in the pleading? The red
My
bond,
lords,
the red bond share, the shares of red bond.
Yes, may I just read out paragraph 4 of that application? My lord doesn't need to see the paper. I'll just read it out for my lords. Because my lord has heard.
But may just minute have a talk with him so that the matter may be cut short. Expedite করে নিলে 3 সপ্তাহ 2 সপ্তাহের মধ্যে শেষ করে নিলে as just minute inquiring whether minute he is amenable to the proposal of expediting the hearing of the injunction
Because you're
application.
already covered by a status quo.
Yes. So
Before that
and-
ends, you
And
want to
there
have
is,
the injunction.
and there's one more thing I should apprise my lords, why we have also
without troubling
filed
your
an
lord,
intervention.
we can do that.
Yes, we can do that, my lords.
It
because the
was one
injunction
rupee cost for traveling us with the genealogical table, but because a learned junior argued, we are not doing that.
Only two things, my lords. One is, this is for them to argue actually why we have also
So
filed.
Lakman is praying that your matter goes on for some time. He's preparing his matter.
Yes, my lords. Only thing is,
My lord is mine.
Oh, very good.
I don't know
Excellent.
which one to prepare, one of the previous one. or the
That's
next
the cost of having too many matters. You have to bear with that.
so yes, my lords, if my lords can direct us back and get the injunction application heard,
Be
then
happy to do that.
we
one
will
matter
also
short.
not stand in the way.
Very good. Yes.
And because the status quo, like I
Say that you have not gone into the merits, the usual thing.
my lords, it can be heard out there.
So we can make it on consent then on this aspect.
Only now, lordship.
You,
Only
your consent is not difficult because you are winning the.
I need to.
He requires consent.
He requires consent. Only other thing, my lords, this revocation case, which arised from the original suit, the OS case, that case seems to have been reopened by a coordinate bench of this High Court.
That has no direct
So
bearing.
that
That direct only.
So, lordship, that is why the matter is pending in the Supreme Court. So when a lordship fixes a time,
What is the
even
stage
if-
of the injunction? You have filed your objection. Both of you have filed your objections. Written objections.
39(4) করেছে। হয়েছে?
Oh, written
yes,
objection
my
to
lords,
the
I've been
injunction.
told it's been filed.
Readings are complete.
Yes, yes. The
You have
PD
also filed.
because when we were arguing, we had
Any date has been
Right.
fixed for that.
lordship in the impugned order. There was a date. Lordship, I have been told I'm not given. My advocate on record is not here, but I've been told I'm not given. Lordship then gives me 10 days to file my objection also because everything would be ready.
You say if not already filed,
My
10
lord.
days. And is there a date fixed for the injunction application, Mr. Banerjee? Since the offer comes from your side,
Milord, a 711 application has been taken out. So, Milord, possibly the court is more inclined to hear the demerred application first.
but that has to be taken up first. Say demurrer is allowed, then nothing remains.
So, Milord, the injunction, Milord, that may continue till the demerred application is disposed of, and then, Milord, there. Or,
Then you
Milord,
have to
can be
reverse
taken.
this order. You have to reverse this order.
Milord,
For that
just
to
on
be
the
reversed,
balance, just on the balance
Here
and
it will
equity.
be a
Then they'll have to, they have to consider that.
Here it will be a little.
That we cannot do. We can
Right.
grant them, we'll grant you a week's time, not 10 days. All the papers are with you for the written objection.
My lords.
So,
But then the 711 might come in the way.
711 and injunction will direct the 711.
711 আছে না নেই?
To be heard.
That is different. That's different.
Mr. Banerjee, we can direct the 711 application. They have filed a 711, so you have filed your objection.
My learned friend has
The
filed.
owners.
You
We have
711.
filed or
You have filed an objection to the 711.
711
We'll
objection.
give you 1 week's time for that also.
Milord, if not within a week.
Within a week for injunction, and to direct the injunction application to be taken up if necessary, we shifting back the date and to be disposed of within first is 711, Mr. Banerjee.
Yes.
First 711, immediately thereafter, depending on its outcome, 3912, both are to be disposed of within 4 weeks from your final written objection.
4 weeks.
File the objection.
From
You
the
have already
date of this order.
Lordship, they were given a date to file the written objection much priorly. So, as expeditious as possible, Your Lordship, is our humble submission. Because the injunction application, we filed the Order 39 Rule 4 as has been intimated to Your Lordship. The judge was persuaded that certain facts had not been put before the court at the ex parte ad
That
interim
to the ad
stage.
interim order,
Yes, Your
not to
Lordship.
the final order. Of
Certainly,
injunction.
certainly. No, that's what I'm saying.
That does not have any bearing on the 3912 hearing.
Absolutely not. That's
The present challenge has been preferred against an order whereby
Lordship,
the
take your lordship.
applications for vacating an ad interim order of injunction passed in favor of the plaintiff's appellants was vacated. Question: such applications for vacating were filed by respondent numbers 1 and 4, comma the comma who claim to be owners, co-owners of the owners of the property, as well as by the other respondents, comma who are developers. First of next para. During arguments, comma learned counsel for the parties submit that a status quo order is subsisting at present in connection with a different matter which is pending before the Honorable Supreme Court, comma, in respect of the subject property. Full stop. Next para. Accordingly, comma, learned counsel for the appellant, comma, on instruction submits that the ends of justice would be subserved if the temporary injunction application is itself directed to be disposed of expeditiously. Full stop. Next para. Learned counsel for the respondents agree to the said suggestion on principle. Full stop. Next para. We are also apprised that an application under Order 7, Rule 11 of the Code of Civil Procedure, comma, for rejection of the plaint in the suit is also pending before the learned trial judge at the behest of the respondent numbers 1 to 4. Full stop. Next para. In view of such submissions, comma,
1 to 4 and 5 to 9, both.
no, they have not filed 7-11, they said.
Oh, much. My instructions.
Next
I'm sorry,
para.
sorry.
In view of the above, comma, we dispose of FMAT 482
Who
of
said already?
2025 with a direction on the plaintiff's appellants to file their written objection to the application for rejection of plaint within a week from date. Full stop. Similarly, comma, the defendants stroke respondents shall file their respective written objections to the injunction application under Order 39, Rules 1 and 2 of the Code of Civil Procedure, comma, if not already filed, comma, also within a week from date in the trial court. Full stop. Next para. The learned trial judge is requested to dispose of the temporary injunction application, dispose of the application under Order 7, Rule 11 of the Code first and immediately thereafter, comma, subject to the outcome of the same, comma, the pending application under Order 39, Rules 1 and 2 of the Code, comma, both preferably within 4 weeks from the date of filing of written objections to the temporary injunction application. Full stop. Next para. We make it clear that while deciding the application under Order 7, Rule 11, as well as Order 39, Rules 1 and 2, comma, the learned trial judge shall not be unduly influenced in any manner by any of the observations made in the impugned order and shall decide the said application independently in accordance with law. Can 1 of 2025 is disposed of consequentially, no arrest to cause urgency.
Since new facts are now supposed to get emerged in their opposition to the injunction application, may I have a chance to reply?
Reply that the proceeding in the trial courts is not there.
Your Lordship,
Because I cannot deal with the facts.
Your Lordship,
Otherwise,
if I may
order.
humbly indicate,
3
we have
days
filed
before
that
the
written
same
objection.
charges.
We have filed a written objection to the temporary injunction application. We have
If
filed
not
that.
already filed website because he was not sure.
No, we have done it. So if they want to reply, then
Allow us to put in a reply within
No.
3 days.
We won't change the procedure of district courts.
And in one of the initial paragraphs, if Your Lordship kindly indulges me, in one of the initial paragraphs, Your Lordship had written respond numbers 1 and 4. Should have been respond numbers
We'll
1,
make
2,
it
4.
1 to 4, however. 1.
Grateful, Your Lordship.
Yeah.
Thank you. Last order.
Mr. Lakshman, you read in the previous matter? Or you have prepared issue in the next matter? Next matter, take all. At time.
তুমি শুধু বলতে বলো 7-11 তোমার আছে ফাইন
Yes.
My suit for partition. My learned friend took out an application under Order 7, Rule 11, saying that the suit is not the claims. Relief's claim in the suit are not properly valued. Because he says that the entire value of the property should be the valuation of the suit. Whereas in the plaint we have admitted and Mr. admitted position of fact that we are in possession of some portion of the property. So going by the Suit Valuation Act and the West Bengal Court Case Act, if in a suit for partition a co-personal is in possession of some portion of the property,
It's a partition suit.
Suit for partition, not for recovery of possession as such. So value of the property can never be the value of the suit. Partition suit would be separately valued. From his Order 7 Rule 11 application, my lord, he filed, my lord, initially a revisional application that, my lord, that was withdrawn. My lord, it was understood, is recorded in my lord's previous order that, my lord, he would be, my lord, entitled to argue his order 7 rule 11 points, my lord, demerit points first before your lordships. My lord, if he succeed in that, my lord, my application for receiver, where from, my lord, this, my lord, my appeal has, my lord, arisen, that would become, my lord, redundant. So if he can, my lord, convince your lordships on, my
So
lord,
7-Eleven was allowed.
no. 7-Eleven was rejected.
Rejected.
And, my lord, my application for, my lord, appointment of receiver at the same time
By
was
the same
also
order.
rejected. Yes.
Well, Mr. Lakman, you can argue. It's a demurrer in the nature of a demurrer, so I will hear you first.
Yes, my lord. My lord, I had filed an application under Order 7, Rule 11. My lord, that wasn't rejected. It was disposed of. It was treated as one under Order 7, Rule 10. And my lord, the plaint was returned
Oh,
for want of pecuniary jurisdiction.
all right.
So, my lord, which is why, my lord, I had, my lord,
You wanted an outright rejection. That's why you wanted.
yes, my lord, my lord, we had also, my lord, approached your lordship, my lord, by, my lord, in like a cross objection. So, your lordship had recorded an order that when this appeal, their appeal is heard, my lord,
Take this point.
my points would be. Now, my lord, the brief history, my lord.
Your point was of valuation.
No, valuation was one of the points, my lord, which the learned judge, my lord, agreed with. But, my lord, primary, my lord, contention is that, my lord, they have suppressed, my lord, a history of litigation on the same property and have tried and, my lord, filed another suit and, my lord, get an order.
Can we deal with that in 7-Eleven?
My lord, of course.
Detailed facts suppressed. That can only come in when you file your written objection or written statement then.
My lord, may I just indicate, my lord, brief, my lord. My lord, a suit was filed in the year 2000 for, my lord, the partition of this property.
Can you look beyond the plaint and the documents relied on therein? In Order 7 Rule 11, time and again it has been held.
My lord, if it is barred by the principles of res judicata, if
res judicata is a mixed question, then you have to bring out the points before the court. Court has to see the previous suit, the plaint, the judgment passed on that, and decide it on merits. It has only to be after framing of an issue and adduction of those evidences. The previous plaint has to be exhibited. You know what is to be done. The previous judgment is to be shown to the court. Cannot be decided at the 7-Eleven stage. So 7-Eleven goes, let us hear the receiver. And 710, it has already been returned.
It has been returned.
I mean, unless we accept his argument and set that aside also, then 7-Eleven suppression of detailed material facts. Your point was primarily res judicata. I mean, suppression of those material facts which lead to
that
res
the
judicata.
property already stands partition. And, my lord, one more thing, my lord.
Yes.
That, my lord, the necessary parties have not been pleaded in the.
All the co-sharers have not been.
No, my lord.
That was also your
In
point.
fact, yes, my lord. In fact, my mother, who actually is the owner of the property, in whose favor there's an arbitral award, she has, my lord, not been made as a, my lord, pleaded as a party in the partition.
In the plaint, four corners of the plaint, we cannot derive your mother's title. That is not admitted.
No, my lord. So from the plaint, my lord, your lordship will be able to see that my father, my lord, is said to have, my lord, a share in the property. Now he is dead. So, my lord, under Hindu law, my lord, mother also, my lord, gets a share. So from that perspective also, my lord, the mothers.
When did he die? Before 1955, 56?
No, my lord. The man dies, wife even today has a share. My lord, I'm not talking about daughters.
When did the man die? Before 1956 or after 1956?
After 1956.
Yes.
After 1956. So, my lord, when, my lord, the gentleman dies, my lord, his widow and, my lord, the sons. Of course, after the amendment of 2005, also the daughters. But pre-amendment of 2005, my lord, the sons, my lord, acquire, my lord, an equal share. So one contention is that in the previous suit which was filed before the High Court referred it to arbitration. Arbitrator passed an award, never challenged. So by that award, the mother became the exclusive owner. But even if, my lord, that
was a partition award.
Yes.
Passed by an arbitrator.
Passed by an arbitrator. Suppressed.
So not a decree. Arbitral award.
Arbitral award. Of course, there are cases that it's by two arbitrators. So
ticks all the wrong boxes.
No, my lord, two arbitrators also can pass an award. There is law to that effect, my lord. I will show your lordship. So, my lord, one contention. Kindly consider, my lord, two alternative scenarios. As per, my lord, my contention, my mother.
You have been joined. Your mother is still alive.
Yes, yes, mother is there. She has not been made a party.
So only non-joiner of your mother.
Yes.
For that plaint can be rejected, or they should be given an opportunity to join. What's the law?
My lord, I would say, my lord, your lordship, my lord.
Let me put my phone on silent mode because thankfully it did not ring. Bell rang after you said that the plate can be rejected on the ground of
These are the points my lord, that have been, my lord.
Difficulty with people who know the law, Mr. Lakman, when they argue, it's difficult for them to support certain things. We understand the difficulty. We have been through that throughout our practice life.
So anyway, my lord, these were the points which were taken. That, my lord, the mother has not been made a party, although she was a party, my lord, in the
previous arbitral.
In the
They were
previous.
parties to the arbitral proceeding.
Yes, yes, of course. So they had only filed the earlier suit. In their suit, an arbitrator was, my lord, the High Court, my lord, volunteered to suggest that you please go to an arbitral tribunal. So two relatives were, my lord, appointed as arbitrators. And those two relatives, my lord, then passed an award, giving, my lord, me a portion of the my mother a portion of the property, and giving his mother a portion. Two women were, my lord, it was chosen that these two women will now own the property. After that, my lord, they left that property forever. This is 20 years ago.
So that was given effect.
Giving, yes, yes. And they gave us some cash, and there's a flimsy letter saying that you have now become the owner of the remaining portion also. I am treating that to be an agreement for sale. Because admittedly, the property was partitioned. And the two women, my lord, were given, my lord, the share by the arbitrator. So if that is, my lord, attained finality, then pursuant to, my lord, the award, parties have acted further, and on a flimsy, my lord, handwritten some cash, my lord, is shown to have been given more than 20 years ago. So that my contention is that I am entitled to, my lord, specific performance of that particular flimsy letter, which is the agreement for sale.
Have you filed a suit for specific performance?
Not yet, my lord, because it's my mother who is to file the suit.
At best, an actionable claim, even if you have a claim on that.
Yes,
that
but
does not create in present right.
Having said so, the property stands partitioned. And my lord, the fact that they have not been there for more than 20 years would, my lord, also be evident from their own plaint, where in the earlier plaint, my lord, they've given the address of the suit property. But now, my lord, that they have sued me, they have, my lord, given the address of their new place in Newtown, where they've been living for more than 20 years. So it's a classic case, my lord, of, my lord, a previous generation having settled. And now, my lord, when some people of the previous generation are dead, and some, my lord, are alive but not, my lord, as active, my lord, the subsequent generation is, my lord, taking another attempt, my lord, to get, my lord, a greater share in the pie. This is, my lord, the fact.
All these things were suppressed in their plaint.
All these things were
arbitration and everything, previous partition.
Filing of the previous suit for partitioning of the same property, number one. Number two, the suit culminated, my lord, in an award.
So everything which happened pursuant to that.
Number three, pursuant to the award, the suit was not pursued by the parties. It was dismissed.
Partition, there is no, it's a continuing cause of action.
Yes.
Order and rule line does not apply otherwise. Apart from that arbitral award, which was passed on consent and they acted upon.
So, my lord, there is one, my lord, recent decision, my lord, if your lordship may, my lord, consider, of, my lord, the Supreme Court, where, my lord, it says that dismissal of a suit, and, my lord, similar facts, my lord, between family members, abandoned proceeding, and then again, my lord, an attempt to file a new case. My lord, Supreme Court has, my lord, frowned upon this conduct and held that although strictly Section 11 res judicata doesn't apply to a case which stands dismissed for default, but then the principles of res judicata will still apply. And, my lord, there is a long Latin maxim, my lord, which I'm struggling to pronounce. It's, my lord, written.
You are struggling with the proposition.
My lord, kindly just consider this
Section
one.
11 would apply to an order and rule line scenario that has been held by the Supreme Court. Are you serious?
My lord, your lordship will just consider. Yes. On those lines, my lord. To the extent, my lord, that I am trying to interpret, I may be wrong, my lord, subject to correction. Give them a copy, no? My lord, kindly
That
take
constructive res judicata judgment. Order to rule to and constructive res judicata, or this is a different one?
This
No.
is, my lord, no, my lord, I believe this is, my lord, where Order 9, Rule 9 has been, Order 9, Rule 9 and Section 11, my lord, have been compared. My lord, kindly, my lord, consider from paragraph 32.
Yes. 32.
Though res judicata is not applicable here, we find the appellate court to have referred to the maxim so and so.
No, so and so you have to pronounce. We'd love to hear you pronounce that Latin maxim. We can't pronounce, that's why we ask.
Debate B.
Starts with Nemo.
Nemo debate B. Vexari C. Constat Curie Bod Sit Pro Una et Iedem
Half the battle won.
Causa.
Half the battle won. Now we continue.
My lord, if I may tell your lordship, my lord, the Latin maxim, which was the motto of our college, my lord, was
Which college are you from?
the Government Law College in Bombay.
Bombay.
My lord, it's Asia's first law college of 1855.
Achha.
And my lord, the maxim, we are perhaps the only college with a Latin maxim. My lord, it said ne vile fano, which means let no evil enter. And my lord, it took us, my lord, a long
You
time.
highlighted that. You're one of the most mischievous people and you entered that college. Yes.
My lord, I believe, my lord, everybody who enrolls ends up violating, my lord.
Yes. So let us continue.
Yes. So, my lord, if your lordship considers from paragraph 32, with this principle in mind, coupled with the fact that the relief for specific performance, as it stood prior to the 2018 amendment of the Specific Relief Act, was discretionary in nature, we move forward to examine whether the case of the appellants falter on application of these principles. Then, my lord, 33. According to Black's Law Dictionary, the said maxim means that no one ought to be twice troubled if it appears to the court that it is for one and the same cause of action. In simple terms, once a dispute relating to a particular cause has been brought before a competent court, the same party cannot be allowed to raise the very same issue again in another proceeding or at a later stage. The rule is meant to prevent repeated litigation over the same matter and to ensure finality in judicial decisions. It protects parties from being subjected to multiple proceedings based on the same cause. As we read and understand the maxim, it is different from res judicata in the sense that its application in a given situation does not require a decision on merits to be rendered in the earlier round of proceedings before the court. Then, my lord, some decisions, my lord, have been referred to on this point, my lord, from paragraphs 34. And my lord, again, if your lordship then takes paragraph 37 and 38.
The judgments are all on res judicata. The court says it's not res judicata.
Yes, my lord, your lordship will just because, my lord, this is, my lord.
The difference is, you know, Mr.
My lord, I understand the difference.
This is decided, it's no longer res judicata. Decided issue conclusively, that's res judicata.
I understand. But, my lord, to file a proceeding and then, my lord, abandon it. And in
that could at best be covered by order to rule. Order to rule. Unless there is a conclusive adjudication on an issue, there cannot be either res judicata or constructive res judicata.
My lord, it says so that
It says it's not res judicata.
It says it's not res
The
judicata.
judgments quoted are all res judicata.
Yes, no, but my lord, subsequently, if your lordship will just consider a few more paragraphs thereafter.
Yes.
My lord, 37, 38, and then, my lord, from maybe from 40, 42, my lord. May I just place these? My lord, my entire argument is based on, my lord, this decision which I was, my lord, lucky to find.
Good. It will make us our task easier.
Yes, yes.
Yes.
Yes. My lord, if your lordship can distinguish this, my lord, then this point.
No, that we may not is opportunities. But our task becomes shorter. We have to deal with only one judgment.
Yes. No, my lord, res judicata perhaps will also, my lord, apply because of the award. The arbitral award, that's a decision on merits. So this is, my lord, on assuming that the award is a nullity, which, my lord, they will argue that two arbitrators have passed an award, so it doesn't really make any sense. So, my lord, that is also.
No, there is another dimension to your argument in your favor. I mean, suppose it's not valid in law as an arbitral award even, but the parties, it can be whether it can be constituted as a mutual family arrangement. Because a family arrangement, it's settled law that family arrangement, even if not registered, but if it's acted upon by the family members, that's as good as a partition, full-fledged. So whether that submitting to arbitrator award, irrespective of award, that was a decision. Suppose that was mediation or something like that. a decision was arrived at and parties abided by that. If that is your case,
Yes, my lord.
then definitely you have a point on this. I mean,
So that is, my lord,
not res judicata definitely,
assuming that the
but if you
award
then
is
take the
back.
color of
Even,
a family arrangement,
yes, my lord. That
yes.
is, my lord, the second limb, my lord.
Maybe issue estoppel also to some extent.
So, my lord, this judgment also, my lord, deals with, my lord, principles of estoppel, acquiescence. I'm coming to those paragraphs,
Oh,
my lord,
come.
because the facts are pretty much
Let us see
similar.
this judgment first, then we'll proceed.
Yes, my lord. My lord, paragraph 37.
Your problem will be whether this can be done at the order summary list. That will be the main problem. Let us finish with this judgment, then we'll come.
Yes, my lord. We now proceed to apply the above discussed principles to the present case. It is undisputed that the appellant instituted the specific performance suit in the year 1988 when the field was governed by the unamended provisions of the 1963 Act. 2 years later, they instituted the two suits so and so. The dismissal of both suits in such situation, despite the issues raised therein being central to the dispute over title and possession of the subject property, is a material circumstance which cannot be overlooked while assessing the overall conduct of the appellants. These proceedings were not incidental or collateral. They directly concerned the competing claims over the suit property. Though the dismissal was not on merits, but on account of non-prosecution, the rival claims remained undetermined because of the appellants themselves. May I just pause here? My facts are slightly better because of the award, and in view of the award, parties having abandoned the suit, which was their suit, where I was the defendant, which ultimately got dismissed for default. Now, my lord, kindly, my lord, now that these are the facts, your lordship will now, my lord, see the discussion on the law. My lord, kindly take, my lord, from paragraph 42. 40. My lord, 42, 43, 43, my lord, refers to clean hands. 43 refers to clean hands. 44, my lord, refers to acquiescence, estoppel, waiver. And then, my lord, 45. Kindly take 45. While a dismissal for default may not constitute res judicata in the strict sense under section 11 CPC, the conduct of the appellants in abandoning the earlier suits after having raised a positive case therein attracts the broader principle akin to such. A litigant who set the ball rolling for decision on an issue later elects not to pursue it cannot be permitted to revive the same dispute at a later stage, particularly in collateral or execution proceedings, and that too by seeking to obtain an order behind the back of the contestants. This is the attempt that was made, my lord. They filed a suit before the city civil court after having abandoned the high court proceeding, which culminated into arbitration. To permit such a course would be to allow an abuse of the judicial process. The maxim interest republic so and so.
What no so and so business in our court.
The maxim interest republicae ut sit finis litium reminds us
This reminds us of finis litium.
that it is in the public interest that litigation must come to an end. Courts cannot allow parties to reopen or indirectly challenge issues which they have chosen not to pursue earlier. Quite apart, it would also not be unfair to criticize the conduct of the appellants as amounting to an abuse of the process of the court. Having allowed their earlier challenge to the sale deeds to attain finality, they cannot now seek to reopen the same issue in execution. Such attempt is impermissible. The process of the court cannot be used to revive what has already been consciously abandoned. This position stands squarely covered by the decision of this court in KK Modi versus KK Modi, wherein it was authoritatively held that relitigation of an issue already raised or capable of being raised constitutes an abuse of the process, even if the strict requirements of res judicata are not satisfied. This court held thus. The Supreme Court in then, my lord, another decision, my lord, is referred to on similar lines. And, my lord, then 48, if your lordship may consider. My lord,
yes.
48. In the exercise of equitable jurisdiction, this court cannot ignore such conduct where a party plays fast and loose with the court, allowing proceedings touching upon title to be dismissed for default while continuing to pursue relief in another proceeding concerning the same property raises concerns as to procedural fairness. Equity frowns upon selective prosecution. A party cannot act recklessly with the judicial process, invoking it as per his convenience and abandoning it when convenient, only to resurrect advantage in execution. A profitable reference can also be made to Order 23, Rule 1, CPC, where the underlying principle is that when a plaintiff once institutes a suit in a court and thereby avails of a remedy given to him under law, he cannot be permitted to institute a fresh suit in respect of the same subject matter again after abandoning the earlier suit or by withdrawing it, except with the permission of the court to file a fresh suit. Reliance may be placed on such so and so, wherein this court explained that such a bar does not arise from Section 11 CPC, but the public policy embedded in Order 23, Rule 1 thereof. The object is to prevent a litigant from repeatedly invoking the court's jurisdiction on the same cause of action, abandoning the proceeding when it suits him, and then re-agitating the same matter again. The court herein held as follows. And then again, another decision is quoted. And then the conclusion on the subsequent page. It nips it in the bud, and it holds that even though the courts below have gone on the basis of res judicata, although we acknowledge that this is not strictly res judicata, but it is hit by the principles of res judicata, and this is a complete abuse of the process of law. So, my lord, suit filed in the year 2000. Arbitral award ultimately, my lord, passed in 2002, where property is partitioned. Award never challenged. No proceeding filed, my lord, neither a 34, and this is, my lord, an arbitration under the 96 Act. This is not an arbitration under the 1940 Act.
Award was in 2002.
I'm sorry?
Award was in 2002.
Yes, award is of 9th February 2002. So suit is of the year 2000. The learned judge referred the matter to requested the parties agreed to go for arbitration before two relatives. And 9th February 2002 is the award, not denied, not disputed. Legitimacy of the award is today being questioned. And then, my lord, 12th March, another date, 12th March 2004 is that, my lord, letter, flimsy handwritten letter that we have paid you the money and we are leaving and this property is now yours. My lord, an uneducated sale, so to say. Which I cannot say, my lord, is a complete.
They paid you money.
No. They acknowledge that we paid them money, 10 lakh rupees in cash. And today,
that constitutes a valid transfer.
Of course, it doesn't. But I can always say that that's an agreement for sale for which I'm entitled to sue when you refuse to.
Have you sued for specific performance within 3
My
years?
mother will get a heart. It's my mother. That agreement is in the
Father, we are not interested. Have you filed a specific performance suit with?
I have not. My mother will file.
Mother has filed.
Mother has not. Mother doesn't even know. She'll get a heart attack if she learns that this argument is being made today before your lordships.
We are getting a heart attack at the arguments. That Order 9, Rule 9, res judicata, Order 23, Rule 1, only 116 Evidence Act is left out. If we don't get a heart attack by the end of this argument, then Mr. Lakshman, then we may survive to pass a judgment.
My lord, I am addressing your lordship, my lord, on also, my lord, their application, which is for appointment of a receiver. My lord, these facts. Yes, my lord, these facts, my lord, are, my lord, your lordship will consider
for both.
For both, my lord.
Very.
So, my lord, then, my lord, after, my lord, this 2004, 12th March 2004, that letter, and my lord, then, my lord, they leave the premises. And my lord, now again, my lord, after more than 2 decades, my lord, they have come back. Now, my lord, what has happened in the meantime? It's a ground plus 4-storied building. My lord, with passage of time, my lord, our family has expanded, my lord. Children have been born, my lord. The lady's sons were married. So, my lord, a part of the property, my lord, is our residence, which used to be, my lord, the joint residence of the 2 branches of the families prior to 2004. So it's our residence. And, my lord, the remaining, my lord, portions are, my lord, occupied by the tenants who have continued. These are old tenants, my lord, where the rent, my lord, is very nominal, 50, 60 rupees. In fact, if my friend can, my lord, enable me to get an order to get rid of those tenants, I'll be the happiest
You
person.
want a receiver for this specific purpose of purpose of collecting rent.
He wants, my lord, a receiver, my lord, to shame me, my lord,
No, shame is it?
in my neighborhood.
The prayer cannot be to shame them, shame the defendant.
He wants a
What is the prayer? For what purpose is receiver sought?
to, my lord,
Collect rent.
protect the property from being alienated and collect rent. And, my lord, status quo, my lord, my lord, I have no objection to, my lord, an order of status quo. I am agreeable to, my lord, maintaining status quo.
Primarily for collecting rent. Receiver cannot prevent you from executing it.
Correct, yes.
Collect rent.
And I have, my lord, disclosed, my lord, the list of tenants and the monthly rent, my lord, that they
Will
pay.
be affected, although this is not a good ground for supporting around. But if suppose even if a receiver received the rents and is in charge of maintenance of the property also from there, how are you affected as such?
My lord, why? At the end of the day, my lord, I am the one, my lord, who has been running this building for, my lord, since ever. For all practical purposes, my lord, they exited. There is an award, my lord, where the building, my lord, has been partitioned. My lord, equity, my lord, completely is in our favor. Unnecessarily, my lord, why should, my lord, keep aside other factors? Why should I, my lord, today suffer the stigma of, my lord, somebody else having come, my lord, appointed by court to take over a property which for all practical purposes is mine and has been mine for decades? And if your lordship sees their pleading, my lord, my friend, my lord, would, my lord, try and justify that, my lord, but, my lord, those pleadings, my lord, don't make any valid ground for an appointment of her. Just because you say that you are half the owner doesn't mean a receiver should.
Order 40 rule 1, this
The tests, my lord,
tests are not set.
tests are not, my lord.
Those have to be higher tests than injunction, definitely.
Yes. Yes. None of those tests are, my lord, met. And insofar as, my lord, the injunction is concerned, on instructions, I'm saying, my lord, status quo ought to be, my lord.
Injunction is not asked for. If you intend to grant a lesser relief.
No, my lord, because what had happened was that before, my lord, the plaint was returned, an order of status quo was, my lord, operating. And that was on both parties. Which is why, my lord, I welcomed it, because my apprehension is that, my lord, they may want to create, my lord, third party rights, and that, my lord, paper is not worth what it's written on. That sale, purported sale, my lord, that, my lord, we understand.
That won't protect you much.
So therefore, my lord, if both parties, my lord, maintain status quo,
you have no objection.
We have no objection. And, my lord, these points, if your lordship feels, my lord, that I cannot raise it, my lord, in Order 7, Rule 11, my lord, then these points ought to be, my lord, decided at the, my lord, very threshold.
Order 14, Rule 2 is also not applicable in the sense that if it's an admitted position from the whatever materials are there, then it can be the first. We can direct this to be taken up as a first issue.
As a preliminary issue, my lord.
Preliminary issue, there is some difficulty. If you see the language of Order 14, Rule 2, Mr. Lakman, which you are aware of course, that it has to be palpable on the face of law. We often mistake it for a substitute of Order 7, Rule 11. Order 7, Rule 11 can't be done, then Order 14, Rule 2, this will be the preliminary issue, has a different connotation. It has to be palpable from whatever is before the court. That then only it's a bar of law or something like that.
Well, only the only reason
preliminary issue, it will be one of the issues, but this can be decided first. That hits at the maintainability of the suit itself.
Because, my lord, insofar as, my lord, these aspects of the matter are concerned, my lord, arguments are only, my lord, on the point of law. Because facts are, my lord.
No, entirely facts. What are you saying? Entirely facts. Your previous arbitral award, plaint.
But those are not
acted upon.
Those are not disputed documents, my lord.
What is the scope of their disputing unless you bring those on record? At this stage, whether those were on record.
My lord, from the pleadings that have been exchanged also in this appeal.
Regarding the receiver.
Yes, my lord. And also, my lord, in the appeal before your lordship, my lord.
No, appeal will not cut much ice.
Whatever, my lord, between the
court, you filed an objection to the receiver application.
We did file it. And in that, my lord, we have taken the same, my lord.
All these grounds.
All these points have been taken.
Although that's not a part of the pleadings,
so
which comprises only a plaint and written statement, but still those materials are before.
Yes, my lord. My lord, I'm sure, my lord, my friend is not, my lord, going to dispute the document itself. He may, my lord, dispute the
we are not so sure.
Legality.
We are not so sure.
At least, my lord, from the pleadings, my lord, that, my lord, have been exchanged.
So let us see the impeal order once.
Yes, my lord. And, my lord,
heard you first, so let us.
And, my lord, one more aspect, my lord.
Yes.
My lord, on the valuation aspect, that this would, my lord, lie before the Honorable High Court. My lord, it's a building in the Bada Bazar neighborhood. It's a ground plus 4-story structure. My lord, it's a believe okay, 5 house, 5 plot. More or less a 5 my lord, plot. And my lord, they are claiming to be 50% owners and accordingly undivided owners, so to say, in their plaint and seek partition. So, my lord, if your lordship may consider, my lord, Section 7 of the West Bengal Court Fees Act. Section 7, my lord, subsection 8, Roman 8, for partition and separate possession of a share of joint family property, etc.
Yes.
In suits for partition and separate possession of a share of joint family property or of a joint property, or to enforce a right to a share in any property on the ground that it is a joint family property or joint property, if the plaintiff has been excluded from possession of the property of which he claims to be a co-partner or co-owner according to the market value of the share in respect of which the suit is instituted. Now, my lord, his share that he claims is 50%. Under no circumstance, my lord, can this share, my lord, be calculated to be less than 1 crore. Because, my lord, if it is above a crore,
Like difficulties, then there has to be an admission of ouster in a partition suit. If it has to be plaintiff excluded from possession, that can only be by way of specific ouster.
Now, my lord, if
that has to be pleaded and proved by you.
Now,
unless it admitted in the plaint.
my lord, now, my lord, the
Joint
documents.
possession, even if you are physically in possession, it's deemed to be on
My lord,
behalf
I
of all.
understand. I understand that, but my lord,
there is a specific case of ouster made out by you and proved. They obviously have not admitted ouster.
But my lord, the two plaints that are there of the year 2000 and my lord, this new plaint, my lord, the cost title that is all I have. My lord, if I can make a case out of that, that the cost title.
Different address.
Yes.
That is where we are trying to distinguish. So, Lakman, you know this.
Mad.
Physical possession, I may not be in physical possession, but your possession is my possession. You are holding on my behalf, my shares also.
Yes, my lord,
every inch, etc.
My lord, that I understand.
Inch, mile, whatever you say. So that principle applies unless there is a specific positive assertion of ouster and you prove ouster by a positive act. Ouster is different. This applies to ouster. We'll come back and continue.
Very
Yes. Should we look into the impugned order once?
Yes, my lord.
Or you want to continue with that? You can make your arguments.
No, no, my lord.
Whichever way you want to.
Only, my lord, in the plaint, if I may just point out.
Yes.
My lord, in the plaint, my lord, as my learned senior friend rightly says, they have, my lord, pleaded that 2 rooms and 1 storeroom continue to remain in their control and occupation, and that they have been reduced to being in this position, thereby implying that there has been an
that ouster point comes in.
ouster point comes in.
All right.
And my lord, the pleadings also, the defendants cannot unilaterally and exclusively govern, administer, enjoy, appropriate the property. So there is, my lord, that I am unilaterally enjoying the property, which implies their ouster. Secondly, my lord, they say presently the plaintiffs have been restricted to physically possess only 2 rooms, and so there is a restriction, thereby, my lord, an ouster. And thirdly, my lord, the cost title, their address is, my lord, of a different place where they've been living for the past 20 years, as opposed to the address in the first plaint. And my lord, fourthly, that, my lord, there is a prayer. My lord, this prayer I must place. A decree of mandatory injunction, thereby directing the defendants to disclose the true and correct present physical status of the property. So if they were indeed, my lord, in possession, then the question of, my lord, this disclosure of the status of the physical, present physical status of the property, my lord, would not have been made. So their share is 50%. They say they've been reduced from 50% to only 2 rooms on a 5-kata plot with a ground plus 4-storied building. And now they want a partition where they want 50%, and they wish to, my lord, increase, of course, their share from these 2 rooms to being 2.5 floors. This would certainly be above 1 crore in valuation.
We'll consider that.
Right. And, my lord, the impugned order, my lord, your lordship, was, yes, my lord. My lord, in the memo of appeal, my lord.
Yes, we are following that. So you can place the internal page.
My lord, kindly ignore the first
few pages.
Several, my lord, pages.
Right.
Because, my lord, they, my lord, deal with, my lord, the
case of the parties.
no, my lord. It deals, my lord, with why, my lord, the learned judge was facing logistical difficulties which prevented her from expeditiously disposing of the case.
We must be responsible for that at some point. Where is that finding? Is this
My lord,
last twice? No.
yes, my lord. Right, my lord, page 2, my lord.
Yes, page 2, we are looking at that.
I recorded evidence on 4 number of witnesses, heard 1 ad interim injunction application.
These are in other matters.
Yes. So, my lord, my lord, the learned judge, my lord, was, my lord, speaking about her laborious day. My lord, it is necessary to mention that on such and such day, in all 54 number of cases were fixed, and I heard each and every fixed matter on that day by attending my ijlas twice in the first half and second half. Every paragraph, my lord, deals with all this. Last, at the end also.
Surgery and failing health also come in. Last paragraph.
Yes, I faced tremendous difficulty in running my ijlas at the substitute, as the substitute was a new entrant in service, and I had to pass all the orders in each and every record.
Anyway, let us.
All of that, my lord. So, my lord, also, my lord, my lord, next page also. My lord, the meat, my lord, begins from page 3, the last paragraph, the middle, somewhere in the middle, my lord, the application of the plaintiffs for appointment of receiver. So that, my lord, deals with the receiver aspect of the order. Order 40.
What are the reasons for?
My lord, the plaint has been written.
This is a city civil court.
Yes, my lord.
So the High Court should have jurisdiction.
My lord, my contention is, my lord,
Contention.
that the High Court should have jurisdiction. And my lord, the fact that the earlier suit was filed in the High Court, which to dismiss for default because the
That
party,
was also a partition suit.
identical prayer, same parties. Only, my lord, the difference being that here they've dropped my mother out.
All right.
Although, my lord, allegations of fraud have been made, my lord, against my mother, because even the mutation of the property is in her name. And she's also, my lord, the landlord of all these, my lord, old tenants who pay rent. Mother's the landlord, who's not a party.
So what is the reason? I mean, the reasoning starts.
Yes, my lord. So the reasoning, my lord, if your lordship will see, my lord, page 10. The present suit is of such a nature, first beginning, my lord,
Yes.
where petitioners have completely hidden certain facts from the court. I must hold that petitioners never appeared before the court with clean hands. They did not mention in the suit as well as in their application for appointment of receiver that already this matter was filed before the Honorable High Court at Calcutta in its original jurisdiction as a partition suit in which Honorable Court had appointed joint arbitrator. So, my lord, all my lord points have been considered, which I have, my lord,
Now arguing. Yes.
now argued before your lordship. Suppressing all those facts, the petitioners appeared before the court and filed this suit along with the injunction application, which was allowed in their favor. And now they are wanting one receiver may be appointed for Schedule A property so that the possession of Schedule A property along with its administration be completely taken over from the opposite parties by the receiver. From the cause title of the plaint, I can see that both the petitioners are the residents of Teghodia, whereas the opposite parties are residing in premises so and so. They are still residing at the scheduled suit property. Now I wish to come to the point of pecuniary jurisdiction. My lord, on pecuniary jurisdiction, the learned judge directs, my lord, that the plaint be returned.
What is the reason given?
Yes, my lord, along with written objection filed by opposite party, clearly mentions that the present market value of the suit premises is rupees 2 crores 99 lakhs 92,782. That goes to suggest that the property is worth around 3 crores, and it is understandable also when petitioners mention in their application under Order 40 Rule 1 and 151 that the Schedule A property is a 5-storied building having around 40 rooms in it. The said Schedule A property situates at Posta so and so on roadside, so its present market value can be assessed by even laymen. So this court does not have any hesitation regarding its market value. My lord, may I just pause here? So, my lord, 40 rooms is, my lord, their pleading.
What is the upper limit of city civil code now? 1 or 10 crore?
I'm sorry. City civil code, my lord, 1 crore.
1.
Up to, my lord, below 10 lakhs, my lord, is only city civil court. Between 10 lakhs and 1 crore is concurrent.
Right.
My lord, in fact, Bombay High Court now, my lord, I'm sorry to deviate, has made its jurisdiction 10 crores for suits to be, my lord, filed before the High Court.
There's a, I mean, on that also a debate is going on now.
And my lord, there was a matter, my lord, before the my lord, Honorable Chief Justice of India. My lord, I happened to be, my lord, doing that matter. So, my lord, it was for appointment of, my lord, an arbitrator. Where your lordship's order, my lord, I was defending, my lord, before the Honorable Supreme Court. Your lordship had said that matter must go to arbitration. Supreme Court said so. And then, my lord, was appointing a learned district judge as the arbitrator. My lord, we said that kindly consider appointing a retired High Court judge or a senior member of the bar, because the stakes, my lord, are involved are at 2.5 crores. So, my lord, the learned CJI, my lord, remarked that for such small stakes, my lord, a retired High Court judge shouldn't be appointed, my lord. My lord, I fell short of saying out of nervousness that, my lord, sitting judges, my lord, in our court are, my lord, adjudicating suits worth 13 lakhs, 14 lakhs, 18 lakhs. And most of them are, my lord, money being played around with.
Yes.
This kacha pakka business. My lord,
yes.
Geographically, the jurisdiction, my lord, ought to expand perhaps. And, my lord, the pecuniary limits, my lord, can be increased.
There's a debate, ongoing debate on that.
Bombay has expanded, my lord, from time to time. They have, my lord, interpreted letters patent to, my lord, increase geographically as, my lord, the Bombay Municipal Corporation has expanded.
There are conflicting judgments of our court on that also, because in the arbitration field, because of that, which would be the district, the original court having ordinary civil
Yes,
principle.
principle, my lord, on, my lord.
So there are conflicting judgments of our courts on that, because of the concurrence of the jurisdiction between 1 and 10. Anyway, so that's a different thing.
Yes, my lord. So, my lord, she holds that the properties were 3 crores 40 rooms, and they admittedly say that they have been reduced.
This is another sticking point for you, Mr. Lakwani, because if the court says that, and if they value it at certain amount, 70 lakhs something, court of its own does this without any inquiry under the Court Fees Act. Section 11 is not resorted to. That's one of the other difficulties we'll have to face.
Yes, she says that it's so obvious. It's a
yes, it may be obvious to me, my personal knowledge, but whether an inquiry had to be conducted on
no so obvious that any layman, that's the word being used, my lord. That court would
having personal knowledge.
Court would take cognizance of something which is in conspicuous public domain, my lord, on that principle. That something which is so conspicuously known and evident that evidence may not be led for that particular. My lord, on the Evidence Act, my lord, there are these decisions that if something like the reputation of a man, someone like Sachin Tendulkar, he doesn't need to prove that.
No, we don't know about his personal reputation. He's a very good public figure. He's a good sportsman. That much we know.
Yes, to that extent.
About the personal life of
to that, of course, to that extent.
Don't know anything about that. Don't have any idea at all.
So, my lord, that principle may, my lord, kick in. That
yes. So because it's in Barabazar and 5-storied and 40 rooms, which may be quite correct otherwise.
Yes.
Doesn't this trade into the domain of personal knowledge of the judge? Can this be public knowledge that I take judicial cognizance of this? Judicial cognizance is of a very high order, Mr.
Ideally, my lord, an inquiry, as your lordship is, my lord, saying.
Anyway, so. But on principle, it's not dealt with regarding whether a partition should fix valuation should be. This ouster point was not discussed by the learned guidance. Although we can supply reasons also.
Yes, my lord, your lordship can.
We can do that
supply
if the conclusion is correct.
But this ouster point, my lord, was not.
We don't find it here because normally a partition suit has a fixed court fee. You know that. Very. So receiver is not looked into because plaintiff is returned, which is quite correct.
No, my lord.
It's looked into.
My lord, no, my lord. The receiver point, my lord, is looked into and discussed.
So that's rejected also. How can the court, after returning the plaint?
No, my lord, but it makes findings that they have come with unclean hands. That they have suppressed the fact that they had filed an earlier suit. My lord, arbitral awards are referred to. All those, my lord, facts are taken because, my lord, all those facts are taken into account. That equity doesn't lie with them. After 2 decades, they have come. Plaint has a different address now. The earlier plaint had all these points, my lord, which I have argued, my lord, have been weighed, my lord, by the learned judge. So it's not that just because the plaint is being returned, my lord, there's not a single finding on the receiver application.
What is this underlined italic portion? Page 11 of the impugner. This is judge's findings. Why special? I mean, highlighted. Yes, judge's findings, not a quotation from anywhere.
Yes, my lord.
Maybe the crux of the matter in her perception.
Yes, my lord. These are
all right. We hope this is not a part of the written notes of any of the parties. Has an uncanny feeling that this is a part of the written notes.
No, my lord. I believe.
We don't know why this gut feeling is arising.
Written notes were not filed before the learned.
Not filed, thank God. For her. Yes, good for her. Very so these are the grounds.
This is, my lord, the case.
Want to add anything, Mr.
My lord, I would only, my lord, say this, that in case, my lord, your lordship decides, my lord, against me on the demurrer issue.
No, when we are hearing you, we are putting questions against you only. That does not mean that you have
no, my lord, in the event, my lord, then in, my lord, that case, assuming, my lord, that on my demurrer, my lord, if I don't succeed,
yes,
it could only be, my lord, given the stage of the suit. My lord, so, my lord, that question
has to be kept open and taken as an issue.
Has to
maybe
be
first decided first.
All, my lord, and my lord, kindly do not appoint a receiver, my lord. I am open to, my lord, the status quo by both sides. My lord, I
You're
can
also open to accounts.
of course I have tendered and I'll continue to tender. I have a list of tenants, my lord, but my lord, the case for a receiver hasn't been, my lord, made out.
Thank you. Yes.
Milord, may I start with or Milord section 7 clause 8 of Milord the
Yes.
because now Milord the defendant has become a little wiser. Milord, he says that Milord ouster is pleaded in the plaint, which was nowhere to be seen in Milord order 7 rule 11 application or argument. But Milord, I have a duty, Milord, to overcome that. Kindly take section 7 clause 8.
Lord, may I have your lordship leave?
Yes.
Milord, the opening words of section 7 is, may Milord please?
Yes.
The opening words are, the heading is computation of fees payable in certain suits.
Right.
The amount of fee payable under this act in the suits next hereinafter mentioned shall be computed as follows. Kindly just Milord have a look at 751 Roman 5. For possession of land, building and gardens. In suits for possession of land, building and gardens, not being suits referred to in 6, according to the value of the subject matter, and such value shall be deemed to be 15 times the net profits which have arisen from the land, etc. So, depending upon the Milord usufructs. Means the next heading is 6 is for recovery of possession. So, Milord, section 7 draws a distinction between suit for possession and suit for recovery of possession of immovable property. Milord, 5 Milord covers those suits where Milord I want to protect my possession. Suit for protection of possession, which is why 6 is Milord for recovery of possession.
6.
I will come to Milord 8, which deals with partition. I just show Milord the difference between Milord a suit for possession.
West Bengal Court Fees Act নেই?
Oh, Milord, may I hand up my
West Bengal Court Fees Act এটাতে সেন্ট্রাল একটা হ্যাঁ West Bengal WB
खोल ना नेटे खोल ना चट করে may Milord hand up.
West Bengal Court Fees Act একটু আনিয়ে রাখবেন এটা রেখে দিন Court Fees Act ছিল West Bengal
I have to. Thank you.
দেখুন ওয়েস্ট বেঙ্গল কোর্ট ফিস এখানে ছিল আগে দেখেছি অনেকে
7.5 is Milord for possession of land, buildings or gardens. And Milord, kindly Milord take note of the marked difference between Milord the heading of 5 and 6.
Yes.
6 is Milord for recovery of possession. This recovery Milord is missing in 5.
Right.
So Milord, 5 is for protection of possession. Not to gain possession of something Milord which is lost. 6 is Milord to gain possession of something which is lost.
So you mean to say that 5 is for asserting possession?
Protection. Milord, I am in possession, someone is trying to
You are
disturb.
asserting your possession and claiming possession.
Yes.
And seeker declaration not seeker.
Then Milord is on the usufructs. Milord, there is Milord a formula quoted. But Milord, for recovery of possession, it's Milord the market value. Now Milord, kindly turn to 8. For partition and separate possession of a share of joint family property. For partition and separate possession of a share of joint family property. In suits for partition and separate possession of a share of joint family property or of a joint property, or to enforce a right to a share in any property on the ground that it is joint family property or joint property, if the plaintiff has been excluded from possession of the property, does not says Milord, does not say excluded from possession of such share of the property. Milord, that is missing. And Milord, this is not a case of Milord casus omissus. Has been excluded from possession of the property as a whole, of which he claims to be a co-parcener. So, Milord, property of which I claim to be a co-parcener, Milord, I am excluded from the property as a whole.
So you say you are in possession of 2 rooms. That means that you are in possession, not ousted from the entire property.
Yes. What is required under 7.8 is ouster from exclusion from possession of the property of which I claim to be a co-owner. So here, Milord, I claim to be a co-owner of the entire building.
All right.
Nobody's case that, Milord, I am excluded from possession of the entire building. Then, Milord, had it been so, then Milord, kindly see what would have been the court, Milord, suit value. According to the market value of the share in respect of which the suit is instituted. So, Milord, then it would have been 50% of the market value, provided, Milord, I was excluded from the entire property of which I claim to be a co-owner. Milord, there is no other way of, Milord, reading this section. Now, Milord, there is a difference between, Milord, subject matter of suit and, Milord, subject matter in suit. Court Fees Act deals with subject matter of suit. Kindly see, Milord, the language in every section. Kindly take, Milord, section 7 itself. The amount of fee payable under this act in suits next hereinafter mentioned shall be computed as follows. Then kindly take, Milord, again 7.5. In suit for possession of land, 6 is, Milord, for recovery, 7 is to enforce a right of preemption, 8 is for partition. Kindly see, Milord, the nature of headings. Milord, it is essentially relatable to the relief short, not to the, Milord, subject matter in the suit.
Unlike suppose specified value in the Commercial Codes Act.
Yes, Milord, I was about to come to that. Here, Milord, we are reciting. So, Milord,
which is not relatable to reliefs.
Yes. So, Milord, that key judgment is, Ambalal Saravai. So, Milord, that does not come to play. Milord, had it been a suit relating to a property in present time exclusively used for commercial purpose, then, Milord, section 12 of, Milord, the Commercial Codes Act, market value.
Irrespective of the relief short.
Yes.
We have even distinguished in some matters that the
My Lord has done so. My Lord
fees-
Justice Boshak has done
Yes,
so.
we means our High
Yes,
Court.
yes.
That there's a distinction between the reliefs, the valuation of the suit on the reliefs and specified value.
Milord,
which
if
is
it
on the
comes to, Milord, Commercial Codes Act, then, Milord, 1978 takes the back
What
sheet.
will be the relief short?
It takes the back
Has
sheet.
to go take color from the.
Then, Milord, subject matter in the suit becomes relevant.
All right.
But otherwise, subject matter of the suit becomes relevant. Now, my learned friend has shown your lordship, and Milord, there is a, Milord, decision on this. Milord, this is 70 CWN. Milord, little old. Kindly take, Milord, paragraph. Oh, I'm sorry. Bhai, ekটু দাও, আমি দিচ্ছি। Sorry. Kindly take, Milord, paragraph 2. I'll just, Milord, show one line, one sentence. Milord, somewhere, Milord, 7, 8 lines, Milord, Milord, in paragraph 2, 7th or 8th line from the top. In other words, Milord, the sentence starts, yes. And it says that indeed is right. So, Milord, differentiates between subject matter of the suit and the subject matter in the suit. What is valued is, Milord, the value of the relief. And that's how, Milord, section 7 is framed.
And the previous sentence is according to the amount at which the relief sought is valued in the.
Correct.
Thus, the standard to go by is the value of the relief sought, not the value of the subject.
And, Milord, the headings of every clause of section 7, Milord, reflects that. Kindly also take, my lord, the trouble just to have a look at, my lord, section 8, section 9. Kindly see the heading here. Statement of particulars of subject matter of suits. My lord, the concise statement that we, my lord, append to a plaint. My lord, to indicate the subject matter of suit. And kindly see the language also, my lord, of section 9. In every suit in which an ad valorem court fee is payable under this act on the plaintiff shall file with the plaintiff a statement of particulars of the subject matter of the suit and his valuation thereof. Here, my lord, subject matter of the suit is the share.
Reminiscent. You're feeling nostalgic. You're citing
70 judgment and, my lord, 70 visitors. My lord, my wife says I don't have a musical bone, my lord, a single musical bone in my body.
I don't have this sort of things. So who is it? Whoever is playing this, please. আমাদের court officer না তো? Yes. It has stopped.
Yes.
It has come back to current judgments.
Yes, I'm not carrying any.
Moment to do this. Yeah.
So, my lord, the subject matter of this suit is the share which I am claiming, and the value of which would be, my lord, 50% provided I am ousted. Otherwise, my lord, fixed valuation.
Both limbs of your argument.
Yes.
Yes.
Now, my lord, the learned court relied upon an e-assessment slip. My lord, I don't need to argue on that, but still I show it. My lord, kindly just turn to, my lord, that was the only handle which, my lord, the defendant provided. My lord, kindly just have a look at the e-assessment slip at page 183. My lord, this is computer generated depending on, my lord, what I feed into the computer. Which is why it says, my lord, it's self-assessed, self-declared.
And land use is indicated as commercial use.
My lord, I was about to show your lordship. See, my lord, how the learned court was misled, my lord, if I may say this. And kindly turn to page 184. My lord, the last two boxes on the right hand side.
Them.
And this is taken as sacrosanct.
So no inquiry under section 11.
Nothing. Section 11 says may. My lord, how this expression may is to be read, my lord, there are
If
decisions.
the court is of the opinion that the subject matter of any suit has been wrongly valued, then
My lord, the learned judge has been of that opinion, my lord, based on something which could not even have been looked into. My lord, if section 11 is read in the manner the learned judge has read it, then my lord, section 12 becomes redundant. Absolutely redundant.
yes.
Now the learned judge holds, my lord, only on this, that my lord, she doesn't have the jurisdiction. But my lord, shockingly, he first decides, my lord, order 40 rule 1 application, exercising jurisdiction, then says I don't have the jurisdiction to look into the plaint. And my lord castigates me saying that I have suppressed facts. My lord, I'll show the suppressions. Says I have not come before the learned court with clean hands. These are all on, my lord, returning on facts. And she says she does not have the jurisdiction. She na he. Possibly she.
So she holds that you have suppressed material. What is your take on that?
I take your lordship to that. Now, what is the suppression according to the learned judge and according to the defendant? That there was a suit for partition, Millard, which culminated into, yielded in Millard an arbitration, and award was passed and Millard published. We acted on the award. That has been the argument, which is contrary to what is pleaded in Order 7 Rule 11. I'll show your lordship that. And Millard, these are the suppressions. And then Millard, the suit was withdrawn or dismissed for default, and I could not have Millard filed a separate suit after that.
Two counts. One is that Order 9 Rule 9 is one of the aspects, but it culminated in an award. There was a formal award. You submitted to it.
Correct.
1996 Act.
Correct.
No challenge.
So Millard, award
and
is
you acted
binding.
upon it. No
Correct.
challenge plus you acted upon it.
So award is binding. Firstly, Millard, until such time the learned judge was of the view that she has the jurisdiction,
That is your
she
first
could
point.
not have. She could
Order
not.
40
So
will
Millard,
not
all
put it
findings returned are bad in law. All findings. Now, Millard, let me assume that she had the jurisdiction, which we say that she did.
Yes.
Millard, this was a suit for partition. Order 9 Rule 9 does not have any Millard application.
What do you say about the Supreme Court judgment?
I don't think I need to say Millard
No,
comment.
you need to say because we need to say. If we need to say, you have to explain.
Paragraphs 39, 40 and 47.
39?
40 and 47. Millard, I was wondering how Millard, my learned friend, was having the courage of Millard citing this decision.
The Supreme Court
Well,
has the
must be
courage to
his
pass
fairness. Must be his fairness.
it. Court has the courage to pass it. Why not?
No,
Definitely,
must be
bound
his
by it.
fairness.
That is the law of the land. That
Yes.
is 141.
Yes. Millard, nowhere says Millard Order 9 Rule 9 is akin to res judicata. Millard can't be so. Can never be so. And in a partition suit, Millard Order 9 Rule 9 can never have Millard any application. Kindly just have a look at Millard paragraphs 39, 40. May Millard, please.
Yes.
Once a suit is dismissed for default owing to the absence of the plaintiff, but when the defendant is present, the legal consequences under Order 9 Rule 8 CPC come into operation. In such a situation, the remedy available to the plaintiff is circumscribed by Order 9 Rule 9 of CPC, which expressly bars the institution of a fresh suit on the same cause of action. The only course open to such a plaintiff is to seek restoration of the earlier suit by demonstrating sufficient cause for his absence on the date of dismissal. It is further borne out that even the restoration application, one of which was filed admittedly after a significant delay of 308 days, ultimately came to be dismissed for default, and the orders passed therein have attained finality. In course of restoration proceedings arising out of suit number such and such, the appellants had moved an application to bring on record the legal yes. However, no effective steps were taken to pursue the matter to its logical conclusion. The cumulative effect of these events is that the appellants not only permitted the original suits to be dismissed for default, but also allowed the restoration proceedings to meet the same fate. Such repeated non-prosecution cannot be simply brushed aside as a lack of initiative to carry proceedings forward. On the contrary, it manifests that the appellants intended to steal a march by resorting to dubious methods, deliberately avoiding direct proceedings and instead securing orders through proceedings wherein they were not parties. Then, Millard, may I skip over, Millard, up to paragraph 46?
Yes.
Quite apart, it would also not be unfair to criticize the conduct of the appellants as amounting to an abuse of the process of the court. Having allowed their earlier challenge to the sale deeds to attain finality, they cannot now seek to reopen the issue in question. In execution, such attempt is impermissible. The process of the court cannot be used to revive what has already been conclusively abandoned. This position stands squarely covered by K.K. Modi, wherein it was authoritatively held that relitigation of an issue already raised and capable of being raised constitutes an abuse of process even if the strict requirements of res judicata are not satisfied. This court held in Supreme Court in Sweet and Maxwell. Millard, I do not think, Millard, I need to anymore, Millard, trouble your lordship. Firstly, Millard, on Millard Order 9 Rule 8 and Order 9 Rule 9, because this being a partition suit, Millard, those have no manner of application, number one. Now, my lord, coming to the so-called arbitral award. May I show your lordship, my lord, their opposition, page 51. This document is, my lord, termed as an award. May not be, my lord, what the papers on which it is, my lord, typed.
Page
51 of the affidavit in opposition, my learned friend has filed. To, my lord, my application in appeal. To can 1. Arekta copy দেন। My lords have kindly got that. Page 51. This is, my lord, the award.
the award, yes. Yes.
First thing first, my lord, unstamped document. Incapable of being, my lord, implemented, acted upon, executed. An arbitral award is necessarily, my lord, exigible to stamp duty. So, my lord, this is yet to be, my lord, an award, yet to take the shape of an award. First,
Court
Arbitration Act.
ওদের বইটা Understand? What else?
Second, my lord, 2 arbitrators. Kindly have a look at section 10 of the Arbitration Act.
Yes, yes.
My learned friend was suggesting that there can be, my lord, even number of arbitrators. Section 10, my lord, constitutes a bar
Section 10 was
of
introduced
the
later. Introduced later by amendment. I
No,
forgot.
no.
I think that was there
Yes,
from the
yes.
inception.
Since, my lord, the
1996, yes.
and if I am not incorrect, there was a perimetria provision in 1940 Act as well, but that need not, my lord, need not be troubled with that because this is an arbitration under
2002.
96 Act.
2002.
Yes. My learned friend was suggesting this is an arbitration under 1940 Act. Could not
No,
have
no,
been
he did
so.
not.
Yes, he did.
No, he said 96, right?
No,
He said
1940
96.
then, Milord, I am
Clearly
mistaken.
said it's
Milord, I am
under the
mistaken. I am mistaken. My fault. So, Milord, so I am mistaken, Milord, my fault. So, Milord, firstly, unstamped. Secondly, a document authored by 2 arbitrators. Thirdly, kindly, Milord, have a look at page 274
The application.
of Milord, my application. Milord, the applicant is Jamuna Devi Bhattar. My learned friend will correct me if I am, Milord, wrong on facts. Jamuna Devi is possibly, Milord, the mother. Of my learned friend's clients.
Oh, acha.
Hmm? Oh, Chandrakala. I'm sorry. Milord, Chandrakala is his mother. ঠিক আছে হয়ে গেল. Kindly, Milord, take this, Milord, order. This application has been taken out for recalling of an order dated 25th September 2000. So, Milord, this is Amar Mayer application. Amader application. So, Milord, that we have, Milord, accepted the constitution of the arbitral tribunal award could not have been so because we filed an application for recalling of the order constituting, Milord, the arbitral tribunal, whereby Justice Ghosh was pleased to refer all the disputes involved in the suit to the arbitration of Rajkumar Bhattar and
It
Sharad
was
Kaur.
not allowed. You were given leave.
Milord, I was coming to that. So an extension was prayed for, which was extension of mandate 29A. Not allowed. So arbitrator, Milord, loses jurisdiction, cease to have any jurisdiction to publish the award.
That was not decided by the court in this.
No, the court says you kindly take, Milord, 275. Milord, may I just place two
Yes.
paragraphs. 275. Mr. Chatterjee, learned advocate appearing for the party who opposes this application, my learned friend's client, contents that joint arbitrators have already made award ready and it can be published if extension is granted. Kindly mark this. When an arbitral award is allegedly made ready, not published, grant me extension to publish. The Honorable Court says, having heard the respective contentions of the learned advocates for the parties without deciding as to validity and legality of the aforesaid two orders on consent, I am of the view that I cannot grant any extension of time limit under the provisions of the Arbitration Act.
No, but that is without looking into the validity of the consent orders. That is what is.
So, Milord,
without deciding as to the validity and legality of the two orders of
correct. What
not
remains
refused on merit.
What yes. So what remains is award is not published. So, Milord, there is no award.
এইটুকুনি উপর বড় জোর রিলাই করতে পারে যেখানে এটা যদি এক্সটেনশন গ্রান্ট হয় তাহলে ক্যান বি পাবলিশড
চলে যাও কাউকে নিয়ে যাও টাইম চাও টাইম চাও নোট করে
so section 29 applies 29(1) and the other provision 4 and
it's nobody's case that after this, Milord, they approached the learned arbitration court, the court within the meaning of section 2E of the Arbitration Act, seeking an extension of time to publish award. Nobody's case. Milord, the matter stopped here. And my learned friend was continuously suggesting that there is an award.
these documents were produced by them along with the 711 or what? Where did
really go to? Milord, I'll just check. Milord forms part of his 711 application, if I am not wrong.
Appears to be so because
711 application starts at page 175. These are all annexures to them. Then, yes.
Yes, it says. Has to be. You did not bring it.
I
on the
did
record.
not
That
know
is the
this.
ground of
I did not
submission.
know this.
Yes. All right.
And Milord, the learned court, without looking into these things, says that I have suppressed an award.
You did not disclose, but you said it's not material.
Not material at all. I did not disclose. Milord, no knowledge was attributable to me. Milord, I did not know this possibly. I do not know who were the parties to the arbitration, who appeared. Kindly have a look at the language of the award, Milord. This was an unilateral appointment even. All the vices these documents suffer from. One, Milord, kindly again turn to page 51 of the opposition.
But you participated before the arbitrator.
Milord, does not appear to be so.
We have to go back to page 51 then.
Yes, Milord, of the opposition. Milord, the cost title, if I may call it a cost title at page 51, it says, Milord, one individual and others claimants, though not described as claimants, and one lady and others.
Jomuna was your mother.
Jomuna is my mother. Chandralekha is Milord there. And Milord, both of them have nothing to do with the property. I will tell your lordship, Milord, why. Milord, he was on Milord non-joinder of necessary party. Now, who constituted others, Milord?
We are sitting with the parties.
Milord, I will take your lordship to that page 52. Now, Milord, that's why, Milord, I was indicating, Milord, the cost title. Who were the other people? Milord, that is not known to me.
And you are not claiming through your mother?
No. Nor is he.
Oh.
I'll show that. Which is why, Milord, Mr. Lakhvani was continuously, Milord, pressing, insisting upon status quo, so that, Milord, he can, Milord, go on minting money from all the tenants.
Not he exactly, she.
She. So, Milord, she is amenable to the proposal of, Milord.
Lakhvani is making money elsewhere. No. Very well. So this also.
So, my lord, 52 says, page 52 says, kindly see, my lord, the first line at page 52. In terms of the order passed by the Honorable Justice Ghosh, we have been appointed joint arbitrators. My lord, amicably, mutually, my lord, unilateral appointment. In compliance of the order, we entered into reference after various sittings with the parties. Don't know, my lord, who were the parties, perusal of papers, etc. Inspecting property in question after considering all aspects such as rent received, etc. We give our award. Unreasoned. Section 24, possibly, my lord, of the Arbitration Act says, my lord, unless agreed upon by the parties,
Has to be reasoned.
has to be reasoned. 24 na 40, chot kore dekh na. Award has to be reasoned. So, my lord, that's why, my lord, I commented that, my lord, this instrument is not even worth the papers on which, my lord, it is typed and printed. 40 না 24 থাকতো রিজেন্ট হতে হবে বলা আছে সেকশনটা বলে now my lord on non-joinder of necessary parties. So my lord, this is all about suppression. Everybody now. Contents of award. My lord, section 31
Of arbitration and conciliation.
of the arbitration.
Yes, you read out it.
Yes. My lord, it says form and contents of arbitral award. Subsection 3 says the arbitral award shall state the reasons upon which it is based unless the parties have agreed that no reasons are to be given.
Yes.
একটা জিনিস দেখতে বললে দেখে দিতে পারবি না।
Right. What about the
Non-joinder of
no,
necessary?
suppose it was not valid as an award. Let us treat it as a mutual, I mean, but you are not a party, that is your plan.
I do not know whether or not. I mean, nothing transpires from this. I do not know. And my lord, this was not a family settlement.
Why shouldn't you constitute-
Arbitration is an adjudication of dispute, my lord, not a settlement. What is binding is, my lord, family settlement, where, my lord, parties are ad idem.
All right.
It is, my lord, nothing which is, my lord, thrust upon the parties by a third party, be he, my lord, an adjudicator or someone else. Not a family settlement.
Why shouldn't it be constituted to be a mediation sort of, and you agreed to it by they say?
My lord, I have shown, my lord, the order passed by my lord Justice Ghosh. The first line first says, my lord, we took out an application for recalling of the order appointing the arbitrators. Now, my lord, kindly take his
You,
mother.
you are not parties.
Me not be, my lord, I am not quite aware of.
Your side, your
My branch. My branch. Jamuna আমার মা তো।
Let's assign that. All right.
Now kindly take, my lord, his demerit application at page 175.
Yes.
My lord, page 176, paragraph 4, first line is on suppression can't be a ground, Millard, in order 7 rule 11.
Which page?
Millard, page 175, Millard, his demerit application starts. Page 176, internal page 2. Paragraph 4. Millard is on a Millard an allegation that I suppressed material fact. Can't be Millard a ground of order 7 rule 11. I'm not troubling your lordships with decisions on this. Then Millard, kindly take the next page. Paragraph 8 at the bottom of running page 177. That the joint arbitrators, in compliance with the order of High Court, ultimately entered into reference after various sittings, perusal of papers and documents, parties, joint arbitrators passed and published an award. Millard, belied by the documents placed by him on record. Firstly, there is no award, Millard, unstamped document. Could not have been published. It's not made even. And respective parties in permanent nature by a partition in respect of the property in question, which is also subject matter of the suit. Then kindly turn over the page, Millard. That paragraph 10. There's the said CS number, Millard, which according to my learned friend yielded in an arbitration. CS number 256 ultimately came up for hearing before my Lord Justice Banerjee, and on that day none appeared and the suit was dismissed. Millard, what I wonder, Millard, what is troubling me, if Millard in a suit parties are referred to arbitration, suit does not serve.
And the 1996 Act, it had to be under Section 8 then.
He has said so. Millard, kindly turn to the previous page. I'll just show your lordship his own averments. Yes, Millard quoted Section 8 somewhere, Millard, in his demerit application. কোথায় চট করে বলতো? Yes, Millard, page 177. Millard, 7th line from the top.
Yes.
And kindly see, Millard, the averments. Under the provisions of Section 8 of the present Act, court dealing with the suit cannot pass any order, it becomes functus officio. And then says Justice Banerjee dismissed the suit. Should have stopped somewhere. And this 711 application is allowed, molding the relief by returning the plaint, saying that the learned court does not have the jurisdiction. Now, Millard, on non-joinder of necessary party. Firstly, Millard, that can never be a ground. Millard, for rejection of a plaint. Millard, I am not showing, Millard, provisions of order 1. Not required. Millard, this was a trust property. I'll show the documents. Trust property, trust for a limited tenure, saying that immediately after dissolution of the trust by expiry of the tenure, Millard, that property will devolve upon 2 individuals, and then from them it will devolve upon their direct male descendants. So, Millard, mothers are not coming into the picture. And it's now very obvious why Millard, he is happy with Millard status quo, which all the more Millard necessitates immediate appointment of a receiver. He has admitted that someone is Millard taking money, Millard usurping the entire usufructs of the property, who has nothing to do with the property. He was getting sentimental that Millard, his mother would Millard suffer a heart attack. Kindly take Millard.
Has also been pleaded.
Fortunately not. Had it been pleaded, would have been accepted by the learned court.
That would be conjecture. But please come to where
Yeah, show the trust deed.
Trust deed you will show, and also in your order 40 rule 1 application, pleadings as to defalcation or anything of misappropriation or something of that sort.
Yes. Kindly take the trust deed first. May I just show
Page?
them? Page 58
Of stay.
of stay. It starts at page 51. Kindly turn to page 58. Should I, come back?
Just let
Yes,
us.
yes, yes. Yes. 51 it starts.
Yes,
The
yes.
property belonged to one Virja Devi Vattar,
Right.
our foremother. She makes the deed of trust, appoints herself and five other persons, including Jamuna Devi and Chandralekha as trustees. Then page 58, clauses 13 and 14. 13 is the clause which starts immediately after conclusion of the continuing clause. Is clause 13. Then comes 14. May I place this? The trust hereby created will come to an end after 20 years from the date of execution. This is a trust deed of Milord.
They are not alive, the next two persons, these Durgadas and Tulsi.
No, Durga Das's sons are the plaintiffs, Hori Tulsi Das's sons are the defendants.
So only the male heirs.
কি নানা বলছিস Tulsi Das died on 25th October 1999. Durga Das died on 4th November 2005.
Evident from anywhere, plaint or order 7.
They are accepting that.
All right. Yes.
At least further stage, I'm sure they would accept. Page 58, paragraph 13. The trust
13,
here.
14 you have read. So we'll start with this. Let us start with your. We will see those pleadings in your order 40 rule 1.
Yes, yes.
Does
Not very happily drafted.
No, shows the.
Yeah, I'll take your lordship to that. Definitely.
Which page?
Milord, it is at page 185. But now the facts are before your lordships.
No, but we have to proceed by a page.
185. 5 na 6.
We have to go by your pleadings before the
185.
trial court. We cannot, because we cannot look into new things.
Very good. May not meet my lord's tests.
But it has to be there in the
I'll
pleading
show.
set.
I'll show.
Pleadings
Whatever
there.
is there, I will.
Otherwise, you don't meet the threshold.
Yes, but rejection of order 40 saying that I don't have jurisdiction is
That remains. That
so, Milord. এগুলো ঠিক এইভাবেই আমার মাথায় থাকবে। হ্যাঁ, কন্টিনিউ কর। বলো একটু 2:30টার সময়, আমার 0.5 ঘন্টায় হয়ে যাবে। একটু রিকোয়েস্ট কর। The other side is not here.
He's here. Other side is running into the court. Yes.
So, my lord, I was trying to show your lordship, my lord,
Page
that
186, that order 40 rule 1 application
my
where
lord,
the
I will take
ingredients
your
have been
lordship
filled.
to that. My lord, the devolution of interest, that where the mothers have nothing to do here.
Yes.
My lord, non-joinder of necessary party. May I, my lord, meet that point? Then I will take your lordship to my application.
Yes.
My lord, because my lord, Demarat is coming first. So, this was another, my lord, argument, my lord, advanced on Demarat. Kindly, my lord, take the trouble to have a look at page 58.
But that you placed before us.
My lord, I just placed one paragraph. My lord,
Achha.
the next two paragraphs. Plus, I'm sorry, my lord.
You placed clauses 13
Clause
and 14.
13, 14, and my lord 15. My lord, the paragraph numbers are missing, my lord, in the photocopies.
No, we have it.
Oh.
Oh, my brother doesn't have.
13 says, my lord, trust hereby created will come to an end.
13, 14 we have read. Yes.
No, 14, my lord, possibly I have not. My lord, may I just one
We
more?
have read.
Oh,
Yes.
very. Then, my lord, I'm skipping over 14.
Respective male layers, as you
Yes.
said, in equal share.
Very. My lord, need not trouble your lordship with it. And, my lord, on the e-assessment slip, my lord has marked, my lord, commercial. E-assessment slip is at page 183.
Commercial and at the
And
at their
Bastu.
behest.
My lord, 50-50, my lord, commercial and Bastu.
And Bastu, yes.
Kindly, my lord, just take this page along with, my lord, the last page of their affidavit in opposition.
What was that page?
My lord, this is their disclosure of tenants.
183, yes.
Yes.
He
Page
and
76 of their affidavit in opposition.
yes.
My lord, my learned friend was vociferous that this is, my lord, a very costly property, very valuable property. Kindly see, my lord, according to him, what are the rents he is claiming to have been receiving. And, my lord, out of this, I just find, my lord, 3 commercial entities. I am not aware of, my lord, the details of anyone because indiscriminately inducted by them. Salami is taken. And, my lord, these meager amounts are being shown, my lord, to have been receiving by them. Amongst, my lord, all these 20, my lord, tenants they have disclosed so far. My lord, 3 are commercial entities. I can, my lord, figure out 13, 14, and 15. Rest are, my lord, possibly residential in individual names.
Page, Mr. Banerjee.
Oh, I'm sorry, my lord, page 76 of the affidavit in opposition. Sorry, my lord. And in his I'm sorry.
Yes.
In his e-assessment slip, my lord, he divides, my lord, commercial and Bastu, my lord, in almost equal proportions to get, my lord, a higher valuation. In any event, my lord, now my lords have seen 7 clause Roman 8, my lord. So these are, my lord, of no significance, but still. And why, my lord, I am asking for receiver is, my lord, evident from page 76. Now, kindly take my application for appointment of receiver at page 186. Now, my lord, this is my lord, my application for appointment of receiver starting at page 186. Kindly, my lord, straightway come to page 202, internal page 17. My lord, up to paragraph 19, which ends at the top of this page, my lord, the plaints, the amendments made in the plaint, my lord, those are pleaded, the reliefs claimed in the suit, my lord, are quoted. Then kindly take 21. The petitioner submit during subsistence of the efforts. My lord, we got an order of status quo, which my learned friend was referring to. Order dated such and such, the petitioners had learnt about and further noticed the encumbrances by a physical possession of the suit property. Consequently, the petitioners have made further correspondences with municipal corporation under provisions of RTI Act. In response to such correspondences, petitioners very shockingly have learned information supported with documentary evidences that not only the defendants, but rather the respective spouses of the defendants have dealt with and further are dealing with the suit property and has let out a portion of the suit property to unknown persons, entities who have started running their businesses. So, when you're exploiting it like anything, without even making petitioners aware of. Photocopies of documents are annexed. Upon perusal of those documents, this learned court shall find that the wife of the defendant number 1 has let out a portion to one such and such monthly rent of 30,000. My lord, conspicuously missing here. And if my lord sees annexure K, page double, to my lord my application, my lord, I will take your lordship to that. My learned junior is tracing it out. 30,000 per month, Tirak creation. Furthermore, wife of defendant number 2 has let out a portion to Kishan Deora. Kishan Deora is also nowhere to be found, my lord, here in the chart. At monthly rent of 12,000. Kishan Deora runs his business in the name and style of KD Spices. Nowhere to be found here. Annexure Keta bar করে রাখ annexed করিস নি copy bar কর lower court petitioners submit that under no circumstances either in facts law above the wives my lord of the defendants can deal with as impostor is illegal, unethical, highly prejudicial, fraud upon petitioners. Petitioners submit that the defendants are not the sole owners or beneficiaries of the property. Parties to the instant suit are joint owners in 50-50 ratio and can only be administered, governed, and enjoyed by the petitioners and defendants jointly in 50-50 ratio. Petitioners submit, in other words, in any circumstances, defendants cannot unilaterally or exclusively govern, administer, enjoy, and appropriate the usufructs of the property. No right to unilaterally, solemnly, exclusively own the property, ignoring, defying the lawful subsisting rights of the petitioners. Till date, there is no partition. Presently, petitioners have been restricted, that my learned friend has shown to your lordships. Petitioners submit, since defendants have malafide intention to grab, capture, this meets the requirement of Order 40 Rule 1. Swallow the entire Schedule A property by throwing out the petitioners therefrom. Further have mischievous intention to deal with, and they have dealt with, the property portion, etc. Hence, the petitioners have prayed for necessary orders of injunction, status quo, thereby restraining the defendants from dealing with, etc. The petitioners submit now by referring and relying to annexure K. My lord, this should have been there, my lord, annexed to this application. My lord, is missing in this, my lord, application. Since the defendants, along with their respective spouses, are dealing with the property without even letting the petitioners ever regarding the current physical status of the property, hence, in order to give a meaningful prospective effect to the aforesaid order, it's necessary and indispensable so that the property can be saved from dishonest clutches of the defendants, from being unilaterally administered, etc., third-party alienations, and hence the petitioners must respectfully submit that a fit and proper person be appointed as receiver. Until and unless order of receiver is granted, these are the prejudices that would be caused to me and are being caused to me on day-to-day basis. So this is the case, that I have made out. I have made out, and now, once this disclosure has come pursuant to my lord's directions issued in this appeal, and there they are showing 4,960 rupees they are earning from a 5-storied building at Posta. Which is talks the nonsense of any prudent person. Shockingly, absurd.
So we have to prove ourselves prudent by being shocked by others. Yes.
I rely upon my learned friend's prudence also.
What's that too?
Yes. So, a receiver, in my humble understanding, is a must. So that
receiver only for the purpose
collecting rents, maintaining accounts. Don't need to give me money now. Let him keep it in and a separate interest-bearing account.
Why can't that purpose be served by accounts? Because they may manufacture the account.
These are the accounts which are coming forth.
How do you know that these people, this one
only a receiver, appointment of a receiver would throw light on this. There is no other way.
30 and all these here alleged, and annexure K is not here. Do you have a
annexure K is not here?
What was K?
Document showing 30,000 rent and 12,000 rent.
But that are very vital. We need to look at that. Where those not annexed here? If those were before the trial court If we have to say that the trial court was required to look into those, we have to look into those first. What are those? Information received from some authority? You said
RTI information, yes. RTI information from
the
KMC.
corporation have this information?
My lord, if I ask for a trade license, then my lord, I have to show my status and my lord, the rent that I am paying.
You don't even have copies of K.
And I was just inquiring. No,
So don't resort to guesswork. If you're not sure, then don't.
no, it's not there.
That was very vital here
Kalke
for a receiver.
Kalke.
Rely on that. Anyway, what else, Mr. Banerjee? Let us complete now.
So, my lord, the necessary, my lord, essential requirements for appointment of, my lord, a receiver, my lord, those are there in my application. And my lord, his, my lord, objection to this is at page 213. My lord, he is dealing with, my lord, my paragraphs 21 to 29 at page 223. There is no denial that, my lord, this 30,000 is not being paid, 12,000 is not being paid. It simply says my mother has inducted. May I, my lord, place paragraph 13 at page 223.
Yes.
Contents as alleged, my lord, read paragraphs 21 to 29 of the receiver application. 20 to 25 are totally baseless, practicing fraud. Defendant state in terms of the said award, as passed by the said arbitrators, the mother of the plaintiff became owner of divided portion by a partition. Subsequently, she transferred her said 50% share to the mother of the defendant through her husband Durgadas Bhattar after receiving entire consideration money, acknowledged same hand money. These all the more necessitates appointment of a receiver. Said divided 50% to the mother of the defendant in 2004, which facts are well within our knowledge. Their mother since 2004 used to reside, have no locus. So the plaintiff has no locus standi to interfere in the said property in any means. The question of further partition does not arise. No legal strength as the plaintiffs. The mother of the defendant is the sole and absolute owner by demarcated 50% by a award, remaining 50% by transfer as total consideration money of the said demarcated 50% of Jamuna Devi Bhattar received by her husband Durgadas Bhattar against valid receipt. It is categorically denied there is any room possession of the plaintiffs at the suit building near Holdiram, where parents of the plaintiff, my lord, neither here nor there. 29 to 34, my lord, that's different. No denial even, not even evasive denial. So, my lord, this is accepted position, 30,000 and 12,000, even without looking at, my lord, the document forming annex checking. And this is why, my lord, my learned friends client are keen to, my lord, maintain status quo, because status quo would, my lord, add premium to their illegalities. They will get a seal of approval from the Honorable Court of, my lord, what they are doing. So, my lord, firstly, this rejection of Order 40 application, going by learned court's own reasoning, is without jurisdiction, ought not to have done so. My lord, everywhere, my lord, the learned court has gone wrong, with, my lord, the deepest of respect, of course. So, my lord, my appeal is from rejection of Order 40 My lord, the case that I made out is now strengthened. My lord,
Not challenging the Order 7 Rule 10 return of claim.
yes, both.
That too.
Both.
Right.
So, my lord, kindly set the order, my lord, aside returning the plaint and kindly appoint a receiver. My lord, the receiver's remuneration, my lord, may be, my lord, appropriated from, my lord, the rents itself. These are, my lord, instructions.
Yes, Mr. Lakman, you want to add to that? Any result? Because you started first.
Yes, my lord, on that point of, my lord, the trust deed, if your lordship will not see the portion, it says on the male heirs. It doesn't say, my lord, on the male descendants. So male heirs, my lord, would be confined, my lord, to the two sons of the lady who made the trust. Because if the male heirs are there, the two sons are there, then nobody else, my lord, inherits under the intestate laws. So therefore, it doesn't say male descendants. Had it been male descendants, my lord, I would understand that argument that it would go on to only the males, my lord, who follow, my lord, in the line of, my lord, descendants. But here it says male heirs. So once it has gone to the two sons, matter rests there. Now, my lord, when the son dies intestate, it will devolve upon his widow.
Sons are still alive.
No, they're dead. My father's, my lord.
Oh, the sons, yes.
The two sons of the, my lord,
Yes, of the settler.
the settler.
Right.
So settler says it will go to my male heirs. Now, male heirs would include her two sons, but it doesn't say male descendants. Therefore, the buck stops there. And the male heirs get it. And then, my lord, from the male heirs, it will, my lord, devolve as per, my lord, the laws of intestate succession. So if the male heirs have gotten it, so my father got it. So then when my father passed away, my brother, I, as well as, my lord, my mother, who's been consciously kept out of the proceedings, who was a party to the 2000 suit, she, my lord, would get a share. And the arbitrator, my lord, the arbitrators in their own, my lord, wisdom and, my lord, settlement approach have given it to the mother. So my argument, my lord, remains intact that if the award, etc., is held to be valid, to which there's no challenge till date, then the mother's the sole owner. That's my primary contention. Assuming I lose on that front, even then the mother has a share. So my friend can't, my lord, conveniently, my lord, interpret heirs, my lord, to extend to descendants, because the two words have distinct meanings. Class 2 heir is nothing if there's a class 1 heir. Likewise, class 3 heir is nothing if there's a class 2 heir. So therefore, my lord, my mother comes in, my mother's importance. Now my mother, my lord, is the landlady of all these tenants. My lord, information I have furnished. One, my lord, purported document upon which they, my lord, seek to rely, my lord, is not even, my lord, in the records, my lord. Do you have it with you? Just, my lord, I have also checked with my learned advocate here, my lord. He doesn't have it, my lord. So, my lord, just to say that people are alienating this, anyone can make a pleading by that logic, my lord. In any matter, a receiver, my lord, would be appointed. And, my lord, it's a discretionary relief. And, my lord, the discretion, my lord, courts, my lord, are slightly less averse to, my lord, appointing a receiver as opposed to, my lord, appointing an injunction. And, my lord, both injunction and receiver, my lord, are discretionary reliefs. Now, my lord, when the question of, my lord, discretion comes in, conduct of parties has to be seen. When conduct of parties has to be seen, how diligent, my lord, they are in litigating in the past is to be seen. After what gap of, my lord, duration they come to the court, my lord, has to be seen. In the facts of this case, they abandoned the case altogether. After 2.5 decades, my lord, suddenly a suit pops up. On the same, my lord, point, these factors, my lord, I understand, my lord. Now, my lord, I'm not on my Order 7 Rule 11. This is, my lord, for the purpose of, my lord, appointment of receiver. My lord, I would, my lord, submit that, my lord, in view of, my lord, this delay of 2.5 decades, my lord, in trying to, my lord, initiate proceedings itself is a ground, my lord, for, my lord, even an injunction not to be passed. And the reason, my lord, that I am, my lord, inviting an order of status quo on both parties, not just myself, is because, my lord, I understand that although for all practical purposes, my lord, the building was given to me, like I have pleaded, but in law, my lord, the entire title has not come to my branch of the family. That, my lord, flimsy handwritten document, my lord, doesn't, my lord, have much weight insofar as transfer of title is concerned. So therefore, I have an apprehension, my lord, that tomorrow they may, my lord, create third-party rights, and I am the only person to lose because admittedly I am, my lord, having the building to myself. And it's my family that has been, my branch of the family which has grown over the years is residing there. So, my lord, kindly consider, my lord, the situation. On one hand, my lord, your lordship, my lord, has us who have always, my lord, been here since, my lord, we have memory. Admittedly. And then, my lord, on the other hand, your lordship has, my lord, the other branch which consciously moved out, my lord, 2.5 decades ago, where, my lord, their plaint also says that they live elsewhere. Now, my lord, the battle for them is to try and somehow get some chunk, my lord, in what was agreed to be ours. In such facts, my lord, would your lordship, my lord, appoint, my lord, an extended arm of your lordships to, my lord, interfere in, my lord, a family affair of this nature? Whether, my lord, your lordship would exercise, my lord, equity of a higher level, my lord.
What about the award not being binding? Award unstamped.
Now, my lord, insofar as
was not granted.
copies, yes, my lord, copies are given to us. My lord, we don't know whether the original award, which, my lord, the arbitrators have with them, both the arbitrators are alive, both family members.
If you don't know, then why should you reject the plaint at this stage?
My lord, my lord, assuming, let's assume for a moment that the award, my lord, lacks a stamp paper. Let's hypothetically assume so. My lord, even then it does not invalidate the award.
Two arbitrators?
The worst case, my lord, that can happen is that until, my lord, it is duly stamped, I may not be able to, my lord, lead evidence.
No, even number of arbitrators also.
Yes, on that, my lord, may I, my lord? My lord, kindly just consider one thing. Under the Arbitration Act, it says that there should be, my lord, one arbitrator or three. And, my lord, when the three arbitrators are to be appointed, each party nominates one arbitrator. And, my lord, these two arbitrators.
No, section 10 probably. Section 10. Read out section 10 once.
Arbitration Act. My lord, just a moment.
আমাদের arbitration একটা দিন it's a statutory mandate. Find out in your phone and show it to him.
Yes, my lord, we have the book, my lord. Section 10, number of arbitrators. The parties are free to determine the number of arbitrators, provided that such number shall not be an even number. We are there, my lord, number one. But secondly, my lord, when there are two arbitrators, my lord, one from each side, or, my lord, both parties appointing two arbitrators jointly, like in the facts of this case, then, my lord, those two arbitrators are to then appoint a third arbitrator who will be the presiding arbitrator. But the act is silent, my lord, on, my lord, the point as to at which stage of the arbitration proceedings would the two arbitrators appoint a third arbitrator. In other words,
Arbitrators shouldn't be there from the very beginning. One of the arbitrators will come in later.
my lord, subject to correction, my lord, that's what the Supreme Court appears, my lord, to have held in a case. So therefore, I'll cite that decision.
Please, Mr. Banerjee will be entitled to.
Therefore, if the two arbitrators, my lord,
one of the arbitrators, the third arbitrator can be appointed later.
If the two arbitrators are, my lord, in some sort of disagreement, then of course a third arbitrator, my lord, could be invited to come and.
Can't wait to see the judgment.
Yes, my lord.
Arbitrator की पढ़े clear में सुन which
उनको दे देना
3 दिन bench clear में सुने तब लग गया
Kindly see paragraph 17, my lord. Kindly see paragraph 17 on this. This was, my lord, in a section 34, where one of the grounds of challenge was, my lord, these two arbitrators.
Yes.
17, my lord. We are also unable to accept Mr. Venugopal's argument that as a matter of public policy, section 10 should be held to be non-derogable, which is, my lord, what your lordship was trying to suggest. Even though the said act is now an integrated law on the subject of arbitration, it cannot and does not provide for all contingencies. And arbitration being a creature of agreement between the parties, it would be impossible for the legislature to cover all aspects. Just by way of example, Section 10 permits the parties to determine the number of arbitrators provided that such number is not an even number. Section 11(2) permits parties to agree on a procedure for appointing the arbitrator or arbitrators. Section 11 then provides how arbitrators are to be appointed if the parties do not agree on a procedure or if there is failure of the agreed procedure. A reading of Section 11 would show that it only provides for appointments in cases where there is only one arbitrator or three arbitrators. By agreement, parties may provide for appointment of 5 or 7 arbitrators. If they do not provide for a procedure for their appointment or there is failure of the agreed procedure, then Section 11 does not contain any provision for such a contingency. Can this be taken to mean that the agreement of the parties is invalid? The answer obviously has to be in the negative. Undoubtedly, the procedure provided in Section 11 will mutatis mandatis apply for appointment of 5 or 7 or more arbitrators. Similarly, even if the parties provide for appointment of only 2 arbitrators, that does not mean the agreement becomes invalid. Under Section 11(3), the 2 arbitrators should then appoint a third arbitrator who shall act as the presiding arbitrator. Such an appointment should preferably be made at the beginning. However, we see no reason why the 2 arbitrators cannot appoint a third arbitrator at a later stage. That is, if and when they differ. This would ensure that on a difference of opinion, the arbitration proceedings are not frustrated. But if the 2 arbitrators agree and give a common award, there is no frustration of the proceedings. In such a case, their common opinion would have prevailed even if the third arbitrator, presuming there was one, had differed. Thus, we do not see how there would be waste of time, money and expense if a party with open eyes agrees to go to arbitration of 2 persons and then participates in the proceedings. On the contrary, there would be waste of time, money and energy if such a party is allowed to resile because the award is not to its liking. Allowing such a party to resile would not be in furtherance of any public policy and would be most inequitable. So 2 relatives, my lord, they do an arbitration by consent, my lord. Parties have participated in the arbitration and award is passed. Today they can't take this point that the arbitrators were even in number. That would be the most uneven thing to say. And it goes on, my lord. And ultimately, in Section 34, my lord, the court had refused to interfere.
That was a different paradigm. The 34, this does not come under 34.
Yes.
That is a
But
different.
nonetheless, my lord, this is, my
17
lord,
is there. First.
this is, my lord, subject to correction, my lord, the law.
Not by us.
Not by your law.
Not subject to correction by us. Yes. Very.
So, my lord, this is insofar as the award is concerned. My lord, kindly do not appoint a receiver. That's my only humble request.
Since a new judgment has come, may I just revert?
Yes.
Lord, Annexure K is with me now.
After the judgment, it is.
রচিত আমি এই পেজটা দেখাচ্ছি ভাই অ্যানেক্সার কে তুমি 12,000 টাকায় দিয়েছো হ্যাঁ এই যে হ্যাঁ
91
আর এই যে এই পেজটা দেখাচ্ছি ভাই 30,000 টাকায় দিয়েছো
Where is it? 91 and 97.
না এটা অ্যানেক্সার কেটা যেটা ছিল না ঠিক আছে মে হ্যান্ড আপ কাজ করা হবে ডাইরেক্টর দিয়ে দেখালাম যেটা আবার দুটোই রয়েছে pages 91 and 97 12,000 and 30,000 by their wives.
What are these?
Millard, Annexure K2 by Millard receiver application. Millard, these are lease agreements or tenancy agreements executed by their wives. Millard, letting out the property for 12,000 a month and 30,000 a month. And Millard, so far as this judgment is concerned, kindly take also Millard paragraphs 18 and 19. It says, Millard, usually, preferably before arbitration starts, if there are 2 arbitrators.
Preferably, but there may be situations where parties agree.
If
not to
parties agree.
Yes, but Mr. Lakmani is relying on that order whereby parties agreed to an appointment.
No, award does not say so.
No, not the award. Initially, there was an appointment.
The order also does not say so.
Refused to be recalled by
Can you
justice
see
court.
Millard the order?
That first order appointment.
Yes.
Section 8 or whatever.
Yes.
What is that?
Milord, page 271. Subject to correction, Milord, I'll just check once more.
Page 49, my lord, of my lord, my affidavit in opposition.
No, it does. Milord, I stand corrected. It does. It does.
By consent of the parties.
Yes, it does. Nobody, Milord, indicated section 10 then. Anyway, it does.
No, section 10
By
has been
consent.
interpreted by the Supreme Court judge.
Explain. Correct. But Milord, so far as reasoning, section 31, subsection 3, not there. Stamping, not there. Publication, not there. So, Milord, there is no award.
There is no subsequent judgment to this judgment modifying this.
Milord, I need to check.
My lord, once I found this, my lord,
You stop searching.
I just looked up if
For
this has
fear of
been.
finding out something which
No, my lord. Just, my lord, went on to check if this has, my lord, been
Overruled or something.
overruled or not, my lord.
Could
We could not find anything
Right.
that overrules this.
Probably this was not brought to the notice of any subsequent bench. Probably this was not brought to the notice of any subsequent bench of the Supreme.
But if I find this has been distinguished somewhere, Milord, I'll upon notice mention tomorrow, otherwise, Milord, is stop it.
Could you do it by today itself? We'll keep it as to mention then on Monday. Not today, this weekend. Right? Because you have to give prior notice to Mr. Lakmanuddin on this point, on this judgment.
Just
Nothing.
this, just this, nothing.
We have concluded hearing.
Seems
But
like
Milord,
the lordship is
keeping
not,
this
my
as-
lord, most convinced, my lord, with the
Are
reason.
you convinced with any of the judgments you cited today?
My lord,
Our conviction is not important. Article 141 is important. We are convinced with the Constitution. Till now. Till we are judges, at least. Yes. Anyway, hearing is substantially concluded. Push up. Next para. In order to enable learned counsel for the appellants to.
my lord, may I only clarify one thing, my lord?
Yes.
My lord, I haven't.
Complete the sentence. To further deal with the judgment cited in reply by learned counsel for the respondent, comma, the matter be listed on August 24, 2026 under the heading to be mentioned. Yes, sir.
My lord, on the test of receiver and distinguishing, my lord, order 39 and order 40, my lord, all those, my lord, there are so many decisions. I'm not troubling a lordship with those decisions. my lord.
Has to be higher, much higher than.
Yes, my
39.
lord, I'm not troubling a lordship with those.
No, no. But that's why we specifically asked Mr. Mr. Banerjee to show us whether the ingredients were at least pre-read or satisfied by them in the order for to
Yes,
one
sir.
approach.
No, my
That's
lord,
why he placed so much.
frankly, my lord, my learned colleague and my lord inquired whether we should be carrying all those decisions. I said, no, it should not be
That would be a
necessary.
miscarriage of justice
Miscarriage.
or miscarriage of judgment.
If your lordships are sure, my lord, we wouldn't require those.
No, not before. We can't speak for others. We won't be after the judgments you cited. Anyway,
Grateful.
thank you very much. Learned a lot of law today, actually, from you.
I don't know.
Thanks. Acha.
Something came later with the same cost title. Milord, I'll just check it.
So, inform Mr. Lakman
Yes.
beforehand.
Something came later with the same cost
You can
title.
search out if still something comes later.
Great.
We are evolving every day now.
Great. This 2002, 2009 with the same cost title, something came. Milord, I'll just check. Go through.
Look at his expression.
Grateful. Great.
Anyway,
Grateful.
thank you.
Item number 12.
12. এটা তো একজনের কাছে তো লেখতে আমি শুনে নিলাম পরে দেখবেন Sorry. Yes.
No, my lord, I must apologize. My lord, item 9 had been passed over my lord,
Should you make it not to?
can it make it, my lord, not to?
Ninth
Other side also, my lord, was averse to, my lord.
No, ninth not to do. We are not recording any order because we have already.
Yes,
called
my
it.
lord, kindly.
We are not calling it again.
I'm sorry.
Hold on.
But I pay for the applicant.
Yes,
I said, I pay for this. There was a direction.
Yes.
He said, "Smaller."
Are we required to look into the this application as well? Otherwise, we'll just take the paper.
The applications are not yet disposed of.
No, formally no.
Your lordship, for the timing, my lord, it will
For the
not be.
timing, we are just keeping those aside. Physically, we have.
Some document is to be referred, my lord. I'll-
Yes, yes, definitely look out. For the timing, we are just removing from our desk for that purpose. Yes. The paper. কাউকে দীপঙ্কর উনি দীপক Why two appeals, Mr. Rai? Anyway, you open your case, we'll understand.
But, this is an appeal, my lord, arising out of a suit for specific performance of an oral agreement for sale of land.
All right. Only one appeal is appearing in our list today.
Yes, there is only one.
There is only one appeal.
There is only one.
Two numbers are given here. Memo.
My lord,
Oh,
That's a FA number.
FA. Right. Sorry. Yes. তাহলে এটা কি দিলেন এটা কি এটি আরো কপি আচ্ছা লাগলো yes
my lord, I'll just tell your lordship, my lord, the short outline of the suit.
yes
My lord, the plaintiff wanted to purchase a large block of land in Domjur area to set up an industrial park. It was to be a garment hub. My lord, he entered into negotiations with various parties. But a chunk of that land, total he wanted was about 23 acres. Now, out of that, a major part of the chunk of land was owned by one Devashish Pal and others. He is the defendant number one, and his family members. It
Alright.
was so we refer to it as the Pal family. And there was some other land also which was taken from Noskors and others. There's no dispute relating to that. We purchased the land. Now, so far as the Pal family is concerned, they had undivided lands. They also had demarcated lands. Now, so far as the other Pal family members are concerned, we have made them pro forma defendants because neither we are seeking any relief against them nor there are any disputes. They have sold their entire portion of land, both divided and undivided. So far as the defendant number one is concerned, he has sold his undivided portion of land to us. There was, and we say that there was an oral agreement that he would sell his divided portion as well. But at that stage, he backed out. There was an agreement, an oral agreement that we would do certain things, they would do certain things, and ultimately he would give us the land. Now, our part of the obligation we have fulfilled. And partly he has also fulfilled, and it is only in respect of this particular piece of land, which is the schedule to the plain pallet, he has refused.
that is his divided demarcated portion
That is his divided demarcated portion.
Right.
So that's the outline of the suit. Now, may I start
suit is
by-
for what
Suit is for specific performance of that area.
oral yes.
Now, may I take your lordship? Your lordship will take volume 1. I'll just take your lordship through parts of the plain.
Yes.
But what was the agreement and what was my prayer? What I have pleaded. I will take volume 1, my lord. Kindly come to page 10, the suit for specific performance of contract valued at rupees 3 crores 36 lakhs 66,544. But this is the purchase price, which I assured and he agreed. Receiver injunction attachment and consequential release. May I just read the first few paragraphs, from page 11 onward.
The plaintiff is a company should to have been incorporated under the provisions of the Companies Act 2013, having its registered office mentioned in the constitutive hearing. At all material times, the defendant number 1, along with the pro forma defendant number 6 and 32, were the absolute owners of 23.8 acres of land within Moujas, Bipornopara, Muhiari, and Jongolpur on National Highway 6 within Domjur and Shakrail police station in the district of Howrah. The schedule containing the details of the lands along with the sketch map is annexed here to and marked as Annexure A and B. The said property is situated on National Highway 6 and the entrance of the said property is through a private common passage of 30 feet width from the National Highway 6. This is further borne out from a sketch map annexed as Annexure B. The defendant number 5, a company within the meaning of Companies Act 13 and dealing in property broking and or trading, entered into agreements with the pro forma defendant number 6 and 32 for purchase of their respective lands, both divided and undivided shares. Thereafter, by 3 several agreements, all dated 25th February 2013, Surjokanta Pal, Chandrakanta Pal, Subhash Chandra Pal, Rajashree Pal, Saurabh Kumar Pal, Pradeep Pal, Pradot Narayan Pal, Nimai Chandra Pal, Torun Kumar Pal, Varun Kanti Pal, being the pro forma defendant numbers 9, 10, 11, 12, 13, 14, 15, 6 and 7 and 8 respectively, entered into agreements for sale with the plaintiff herein, whereby the pro forma defendant 5 assigned and or nominated the plaintiff in its place and stead for purchase of such plots of land. The pro forma defendant number 5 was the confirming party to the said agreements. The said assignments and or nomination did not include the holding of the defendant number 1. It transpired from the records that the defendant number 1 was holding substantial land in the said total area of 23.89 acres. Since the plaintiff wanted to acquire the entire area of the land for the purpose of setting up of an industrial park, the plaintiff approached the defendant number 1 requesting him to also transfer his holding in the said area scattered in various plots. Various negotiations took place between the said defendant number 1 and the representative of the plaintiff starting from the month of April 2013, and ultimately an oral agreement was entered into between the parties in or about 7th May 2013 to the following effect. Now, the conditions that the defendant number 1 owns total 3.8680 acres of land, which is held as an undivided share as well as divided share. The defendant number 1 shall convey the total area of 3.8680 acres of land to the plaintiff at an agreed consideration of rupees 6 crores 88 lakhs 22,217. That the partitioned area of 151.46 decimals of land, which is held by the defendant as an exclusive area in plot numbers, several plot numbers are there. Mouja Bipanopara, jail number 27, shall be conveyed by the defendant in favor of the plaintiff upon the plaintiff performing the following reciprocal obligations. This is where the subject matter of the suit, that's the property, 151.46. The plaintiff would convey to the defendant number 1 65.640 decimals of land in several plots within Mouja Bipanopara, which the defendant number 1 shall be entitled to hold as exclusive area, for which the defendant number 1 would pay to the plaintiff a sum of rupees 1 crore 24 lakhs as consideration for such transfer. But this has been done. The second condition, upon transfer of the said 65.64 decimals of land, the said defendant number 1 would convey and transfer 65.640 decimals of land in several plots, both in Mouja Muhiari, totaling to 53.99 decimals demarcated, along with undivided 1/7 share in different areas at Mouja Bipanopara and Mouja Muhiari to 11.65 decimals for a consideration of 1.46 lakhs. Number at 1.46 crores. Pausing here for a moment, Ballard, your lordship will kindly note that the land measurement is exactly the same. So basically,
exchange.
It's a sort of exchange, but I am paying a higher price.
Right.
He is paying a lower price. It's
maybe due to the location or something.
It's basically, Ballard, both sides of a passage.
Oh,
It is within this 23 acres, there is a passage in
so you want to
between.
consolidate your portion?
One side. I took this side because I started construction on that side.
All right.
And later on, your lordship will find that I was also going to take this side because when I moved on to that side, it was a phase-wise part. So, for his benefit, I sold him the land at a lower price and I purchased his land at a higher price, keeping a condition that I would again take it again. And that's there in the deed also. I will demonstrate before your lordship. Upon such mutual transfers.
Oh, these terms are somehow find mention in the deeds.
No, it is not there, but not in this language. But from the deeds, I can show that this intention was there.
All right.
That will be there because, for example, Malad, I will show your lordship that because I have sold my plot of land at a lower price, I have always kept a condition that it will be my first right of purchase.
All right.
Back. So from there, Malad,
opposite reading of the,
yes,
we'll go into that later.
Yes, that is the defense taken that nowhere, and the learned judge has also found that nowhere is there any reference to an oral agreement. My case is that from the facts,
circumstantially,
and the transactions,
yes,
your lordships will find that the facts and circumstances and the transactions will show that there was an agreement. Otherwise, both the parties would not have done these transactions.
All right.
It was further agreed between the parties that I'm reading 4. Malad,
yes,
four.
4.
It was further agreed between the parties that the payment to be made by the defendant number 1 to the plaintiff in respect of that's this property. It was further agreed between the parties that the payment to be made by the defendant number 1 to the plaintiff in respect of 65.64 decimals of land would be a concessional price, considering the fact that the said defendant number 1 would be helping out and cooperating to the plaintiff in getting the conveyance deeds executed from the other PAL family members, as I said. It was also agreed between the parties that upon conveying the area of 65.64 decimals of land in favor of the defendant number 1, the plaintiff would facilitate development of the said land and would also provide electricity drainage facilities. It was also agreed that while conveying the 65.640 decimals of land, the plaintiff would also permit user of common passage by the defendant number 1 to enable him to ingress and egress to and from the said 65.640 decimals of land. So, common passage belongs to me. I gave him access because I exchanged that land. It was further agreed between the parties that the defendant number 1 shall convey his rights in respect of 65.64 decimals of land after all the conveyances executed by the family and other pro forma defendants in respect of their entire share in the land. So, in short, the agreement was that he will give me 65 decimals at a lower price. I will buy another 65 decimals from at a higher price. After that, he will sell me that 151 decimals of land, and ultimately, he will give me back that 65 decimals of land. This was the agreement. First two parts, complied. I sold him, he sold me. At this stage, when I completed sale of all the other PAL family members, everything is complete. Then he refused to sell this 151 decimals of land. That is the subject matter. Now, thereafter, I am not troubling your lordship so much with the other pleadings. There are documents. I will just take your lordship briefly through the documents.
Yes.
This ultimately kindly come to page 23. Well, this again, in the meantime, negotiations were going on. We were requesting them to complete the contract. It was again agreed in 2017, paragraph 20 states that in facts and circumstances, the plaintiff is compelled to file the institute seeking specific performance of the said agreement dated 7th May 23 as reconstruction on 3rd August 27. But it's kindly give me a moment. In 2017, they had said that you would complete it. Yes, I'm sorry, but kindly come to page paragraph 14 once. Page 20.
Yes.
Original agreement was in 2013. And well, in 2017, he said that we would do it within 2 years. But I'll just read few lines of paragraph 14. In the meantime, plaintiff has started making construction of the said industrial park upon obtaining permissions from various statutory authorities. The project, however, would remain incomplete in the absence of the said area of 151.46 decimals of land. It is stated that the defendant number 1 on 3rd August 2017 agreed in the presence of well-wishers of the parties that he will complete the full performance of the contract within 2 years.
Sir, I have 1 minute. Mr. Chatterjee, in this matter, is there, you can take instruction, also later we'll hear the matter, whether there is any chance of your client agreeing to getting a higher sum or something like that and selling this? You also take instruction on that. Have you had any talk on that?
Yes, my lord. He says, my lord, his written statement is that, my lord, there was no oral agreement at
No,
all.
no. On merits, yes, we suppose whatever your stand is. But whether your client is agreeable to, because he has sold other portions also, it's his choice whether there is a scope of he's agreeing on a higher price or something like that. Just take instruction
No,
on that
he's
also.
here, my lord. Can I just
You
take
just have a talk with him. And we are not pressurizing, there is no compulsion. And Mr. Chatterjee, one thing that will not dilute his case, just impress upon him. That will not dilute his, even if he. You can think over, Mr. Chatterjee, we can give you time. But in principle, whether we.
Lord, the problem is, my lord, in the property, my lord, this 151 decimal, he has raised a commercial plot.
So there is no scope. Thank you.
So, Malad, in 2017, 3rd August 2017, Malad, he said that he would do it within 2 years. Now, Malad, your lordship will kindly come to the prayers at page 29. Leave under order to rule 2 of the Code of Civil Procedure. Decree for specific performance for transfer of the suit property as described in the shell hereunder, with a direction to the defendant number 1 to execute and register the sale deed in favor of the plaintiff on accepting the agreed consideration, being a sum of rupees 3 crores 36 lakhs 88,544. A decree directing that the defendant number 1 to execute and register the sale deed in respect of the suit property within a time as to this learned court may deem fit and proper, failing which the sale deed be executed and registered according to the provisions of Order 29, Rule 34.5 and Rule 6A of the Code of Civil Procedure. Alternatively, a decree for damages for rupees 127 crores as pleaded in paragraph 20. In further alternative, an inquiry be caused in terms of Order 20-12 of the Code of Civil Procedure to ascertain the actual amount of damages sustained by the plaintiff, and a decree passed accordingly. A decree of permanent injunction restraining the defendant number 1 from changing the nature and character of the suit property till the disposal of the instant suit. A decree of permanent injunction restraining the defendant number 1 and 2 and their men and agents or servants from changing the nature and character of the suit property, making any construction thereon, and restricting movements and ingress of the plaintiff from the common entrance from the National Highway 6 to the suit property, as also the plots of land owned by the plaintiff. A decree of permanent injunction restraining the defendant number 1 and 2 and their men and agents or servants from creating any nuisance on the common passage leading to the suit property and the plots of land of the plaintiff, and for parking vehicles on such passage and creating any obstruction in any manner whatsoever on the common passage leading to the suit property and the plots of land of the plaintiff. A decree of permanent injunction restraining the defendant numbers 1 and 2 from alienating, transferring, encumbering, and or creating third-party rights in respect of the suit property. And receiver injunction attachment first and further release. Now, your lordship kindly takes the schedule.
Yes.
Kindly take the schedule. All that piece and parcel of land measuring 151.46 decimals, that is 1.1546 acres of land, being the land comprised in the below mentioned dark numbers and LR Khotiar numbers such and such at Mouja Biponopara, jail number 27, police station Dokjur, Howrah. Kindly mark this part together with all easement and quasi-easement rights thereto, together with all rights, liberties, privileges, along with the right to free ingress and egress. Then the dark numbers are given, and the description of the property has been given. Now, the learned judge, when I take your lordship through the impugned order, your lordship will find that injunction we prayed also in respect of the common passage, because they were obstructing our ingress and egress, and the learned judge had come to a finding that this is not a part of the scheduled property, therefore he cannot pass any injunction. So that's the reason why I place some stress on the easementary rights so far as the land is concerned. Now, your lordship will kindly take the our order 39 application. It's at page, it starts at page 120. Kindly come to the prayer. But I do not, it's more or less the pleadings of the plaintiff and the order 39 applications are more or less the same. But I just want to show the prayers, then I will go back to the supporting documents. One paragraph prior to the prayers, your lordship will kindly consider. Kindly come to page 142. Paragraph 29 of the first volume.
Yes.
What was the urgency for which we filed this suit and for injunction? There is grave urgency in the matter inasmuch as the opposite party respondent numbers 1 and 2 are performing Bhumi Puja on the suit property and making construction thereof. If the opposite party respondent number 1 and 2 are allowed to change the nature and character of the suit property, alienate, encumber, transfer, or create third-party rights in respect of the suit property, the petitioner shall suffer irreparable loss, injury, and prejudice. So, we came at a time where Bhumi Puja was being performed and no construction was there at that point of time. And what is the prayers? Kindly see page 143. An order of injunction restraining the opposite party respondent numbers 1 and 2 and their men and agents or servants from changing the nature and character of the suit property, making any construction thereon, and restricting free ingress and egress of the petitioner from the common entrance on National Highway 6 to the suit property, as also the plots of land owned by the petitioner. An order of injunction restraining the opposite party respondent numbers 1 and 2 and their men servants and agents from creating any nuisance on the common passage leading to the suit property and the plots of land of the petitioner from parking vehicles on such passage and creating any obstruction in any manner whatsoever on the common passage. And third is an order of injunction restraining the opposite parties from alienating, transferring, and encumbering and creating third-party rights in respect of the suit property. Now, why I laid stress on this paragraph and this Because now, my lord, a submission will come that there is a commercial construction which has been made on that. Now, my lord, we came to court at the stage when the Bhumi Puja was being performed. But we got an injunction restraining them from changing the nature and character of the property. That was carried in appeal. The appeal that order was set aside and it was sent back for de novo consideration by this honorable court. This is the order passed after de novo consideration. Now, unfortunately, my client is unlucky, but this matter was heard and it was reserved for judgment. But unfortunately, thereafter it could not be taken up. When the pandemic came in, there were certain developments they were constructing. We made applications. Your lordship will find there are another. We made police complaints. We filed applications. For whatever reason, it could not be heard. Then we came up before your lordship, and ultimately we got an injunction restraining them from doing anything to the common passage, as also the ingress and regress, egress, and further construction from your lordship. And today, I would also be praying, that they should not be allowed to make any create any third party rights. So far as that is concerned, I will show your lordship, what your lordship order your lordship has passed earlier. Now, kindly see few documents which are annexures to the claim. I'll just take your lordship very briefly through the documents, The first annexure is the list of plots which we have acquired. Yes. I'm not troubling your lordship. Annexure B is the map. But it's in the middle really. 44. Page 44, Malad, is the map.
Yes.
Your lordship can see, Malad, on the right hand side, top corner, Malad, National Highway 6. From there, Malad, the passage is coming in, common passage. And the second plot, which is Malad, shaded, a square box towards the middle, Malad, on the left hand side. Yes. Towards the middle, this is the suit property. This is 141 decimals of land. This is the suit property. The rest, the entire area is purchased by us. And in fact, that land does not have any access apart from this common passage, which your lordship can see from the NH6, and that is also owned by you. You. Owned by you. The deed says, I will show it to your lordship. Yes. Now, of course, it's all our government park is more or less complete, excepting this area which is held by him. Apart from that, on all sides, our buildings are. Now, the next page is annexure C, page 45, is the list of deeds by which we have already purchased from the defendant number 1. Yes. There are 5 deeds, and the total quantum of area that we have already purchased from him is 2.3534 acres. Then, the next annexure D, starting from page 46, is the entire list of land, this entire 23 acres, which we have purchased from the Pal family and also from others. There are total 23 deeds. Yeah, I'm sorry. Total it goes up to 46 deeds, and the total land at page 51 your lordships will find it is 20.19 acres. 20.19 acres. And 3 acres total I am supposed to get from him, so ultimately it will come to 23. It was the original plan. Number page 52, annexure E to the plane, is the deed of conveyance, whereby he, the defendant number 1, purchased. He purchased that 65 decimals from me at a higher price. It starts at 52, kindly see Malad, between Devashish Pal and Malad, he is described as the purchaser. And he, at page 54, Alok Nivas Private Limited, that is the defendant before your lordship, he is the seller. And if your lordship kindly comes to page 55,
Yes.
the last paragraph, and whereas Alok Nivas Private Limited, the vendor herein, is also the owner in respect of that all that passage shown in the delineated in green borders and landmarks text and annexed here to hereinafter referred to as the common road or passage. The same starts from the main public road leading to several plots of land belonging to the vendor herein, which is meant for ingress and egress of both parties of their men and agents assigned transferees to their vehicles, the public road. So this one clearly shows that so far as the common passage is concerned, I am giving them access, but it is my land. And page 56, the second paragraph, kindly see, and whereas the vendor has agreed to sell and the purchaser above named has agreed to purchase all that the said plot together with the right to use in common with the vendor herein, the said passage more fully described in the schedule hereunder, were free from all encumbrances whatsoever for the agreed consideration on the agreed terms. Now, kindly turns over to page 61. I'm sorry, Mulad. Kindly take page 57. It's not. It is obvious, but it's the development part that I'll just read out. Mulad, it is towards the bottom of the first paragraph. The entire common passage originating from the public road ending with the vendor land shall be developed at the cost of the second party. Page 57. The first party is not under any obligation to pay any charges or fees for such development and or improvement of the common road meant for use of both the parties. This is because it is my land, I take the responsibility for development of this. I'm going to kindly come to page 61, just prior to the schedule. And the purchaser above named declare and confirm that the vendor has sold the said plot of land in favor of the purchaser by this deed. The vendor herein shall have the first option to purchase at highest market rate price and or acquire this. So there was an intention that I will buy it back, which is a part of the. And Malad, here also, your lordship will see the next page where the schedule of the property also includes, Malad, after the chart.
Yes.
1, 2, 3, 4, 5 lines. Red borders in many along with the rights of common passage over the 40 feet wide road meant for common use of the parties as delineated in the annexure. Now, Malad, thereafter, Malad, it is there. Now, Malad, kindly come to Malad, I will show to your lordship 3 letters. Malad, kindly take page 81. These letters substantiate my claim that there was negotiations between the plaintiff and the defendant number 1 and the defendant number 1 agreed to. But after they did not sell the land as per the contract, we sent 3 letters. This is the main letter. After that, we sent 2 reminders. But all were received, no contemporaneous denial. And it is only after I file a suit and when they file their written objection to the Order 39 application that they say they do not deny receipt of these letters. They They deny the contents at that stage. There is no contemporaneous denial to these letters. I am place this letter. Kindly mark the date, Palat. It is dated 23rd September 2016. The subject is sale of your landed properties situate at Mouja Biponnopara and Mouja Mohiari, jail number such and such, PS Donjur, Howrah. Dear sir, pursuant to the discussions and negotiations between yourself along with Sri Jagdamba Singh and ourselves, you have agreed to sell your landed property at Mouja Biponnopara, jail number such and such, Howrah. It was represented by you that the landed property compromises of three parts as follows. Your 1/7 undivided share having an area of about 170 decimals in the joint property at Mouja Biponnopara, owned by you along with Nimai Chandra Pal and others, Surya Kandra Pal and others, Pradeep Pal and others, Anup Pal and others, and Prabir Pal and others, and Sri Partha Pradeep Pal. Second is divided and demarcated piece and parcel of land measuring about 200.17 decimal, situate partly at Mouja Biponnopara, jail number 27, and partly Mouja Mohiari, jail number 20. And third is 1/7 undivided share having an area of 11.86 decimal in the common passage, comprising partly in Mouja Biponnopara and partly jail number 20. In part performance of our agreement, you transferred and conveyed in our favor land measuring about 170.907 decimals, being the undivided share in the joint property as stated in paragraph 1 above, on 25/4/14 by 4 several deeds of conveyance registered in the office of the additional district sub-register Donjur, Howrah, and received payment of a total consideration amount from us. In part performance of our agreement, you transferred and conveyed in our favor land measuring about 170 decimals, being 1/7 share in the joint property as stated in paragraph 1 above, on 25/4/14 by 4 several deeds of conveyance registered in the office of the additional sub-register Donjur, Howrah, and received payment of a total agreed consideration from us. Although according to our original agreement for sale of your divided and demarcated piece and parcel of land measuring about 200.17 decimals was to be conveyed first, we had agreed to your request to take conveyance of your undivided land measuring about 170.907 decimals upon your assurance that conveyance of the divided and demarcated parcel of land along with your 1/7 right in the common passage shall be transferred immediately thereafter. Thereafter, on 1/11/2014, you transferred and conveyed a part or portion of the divided and demarcated parcel of land together with 1/7 undivided share in the common passage, together measuring about 65.640 decimals at Mouja Mohiari, jail number 28, and 8.11 decimals in Mouja Biponnopara, jail number 27, leaving the balance of 150.220 decimals. It was assured by you that the remaining parcel of the land measuring 150.223 decimals shall be transferred and conveyed as soon as the sale of parcel of land by other owners who had also agreed to sell their respective undivided shares in the said land, as well as their divided and demarcated plots together with each of their undivided share in the common passage is completed. In view of your commitment, as already stated above, we have acquired the right title and interest of the co-owners, and in order to complete the transaction, you are now obligated to transfer 150.229 decimals in the said piece of parcel of land. Since we have already invested large sums of money based on the commitment made by you, we would request you to kindly arrange for immediate transfer of 150.229 decimals in the said piece and parcel of land together with another 65.64 of the parcel of land aggregating total 215.869 decimals of land. You are requested to fix up an early date for transfer of the said land in our favor. This letter received no correspondence, no reply, no denial, they were just sitting tight. Number two other letters. This was, it's not denied. They have admitted the receipt of the letters. Page 84 is a reminder that is dated 15 February 2017. Sale of your landed property situated at Moja. We refer to the above letter whereby we had requested you to sell and transfer our landed property measuring such and such and partly in Moja Mohiyari. As per details given in the letter under reference, we forward herewith a photocopy of our said letter dated 23/9/16 for your ready reference. Since a considerable time has passed, we request you to fulfill your obligations by transferring said land without any further delay. Then this was 15 February 2017. Again, 2nd November 2017. We again write to them and say, we draw your attention, we give reference to the earlier two letters and we say that we draw your attention to our letters under reference whereby we have requested you to complete sale or transfer of 215.869 decimals of land. Since we have not received any response from your end, we once again request you to complete the sale and transfer of the said land in our favor.
Yes.
Now, we have annexed documents. We have entered into a joint venture agreement with the defendant number. With the defendant number 5, I think.
5 was the broker.
5 was the broker. Just 4. 4, we have entered into a joint venture agreement for development of the industrial park. That agreement also shows, though the defendants are not 1 and 2 are not parties to it, but that agreement also shows that the parties thereto are giving lands which they have acquired till date. And it also says that whatever lands are acquired subsequently will also go into that development agreement to that. Page. I'll just refer to it. But it is at page 549. That's one of the volume 5. Volume 5. It starts at page 549. But this is the development agreement dated 12th of July 2016. It is between the plaintiff and others. And yes, this is a registered development agreement. But we have the sanction of the micro small industries also to set up that hub. It is there, it's on record. And it is between the plaintiff and the defendant number 4. I'm going to kindly come to page 556 at the top. The said SME industrial park project will also include various other lands which may be brought in or acquired by Messrs. Olofnimas Private Limited and Messrs. Satcom Windtrade Private Limited and or contributed by others from time to time, and SD Infrastructure and Real Estate Private Limited shall enter into similar agreements from time to time for which no consent or approval of Messrs. Olofnimas Private Limited and Satcom Windtrade Limited and others would be necessary. So there was an intention at the very beginning that we would include other lands in this, and the schedule your lordship will find at page 569 of this agreement. What are the lands First, your lordship will find the first very name is Devashish Pal. He is the defendant number 1.
Yes.
All from the Pal families, everything is taken, my lord. All the pages your lordship will see. These are all lands taken from the family, including Devashish Pal. And my lord, this has been put into this agreement. Kindly come to page 583. Kindly come back to page 561 once. Construction and completion of the
Yes.
heading is construction and completion. 9.1, my lord, if I may place, inasmuch as the SME Industrial Park is proposed to be developed by SD Infrastructure and Real Estate Private Limited for the time being in force on the first scheduled property and second scheduled property, and the intention of Messrs. SD Infrastructure and Real Estate Private Limited, Olopivas Private Limited, and Satcom Windtrade Private Limited is to expand the total project area by acquiring more lands or by entering into similar agreements with other contributing landowners from time to time. The entire project shall be completed in several phases, and such phased expansion shall be integrated with the project and or the SME Industrial Park, as such approval and sanction plans shall also be obtained in phase. So the intention, my lord, was always there. At page 583, your lordship will find the total land which was acquired as on that date, my lord, from the Pal family comes to 17.1602 acres. Then, my lord, the schedule of the subsequent purchases, my lord, the entire list is given. And at page 588, the total land as on that date which could be acquired and made up part of this project was at page 588 to 21.5623 acres of land. So it is only his part of land which is missing. The rest is all covered by this. Now, my lord, your lordship will kindly take the written objection filed by my learned friend's client to the to his injunction to our injunction application, my lord. Page starts from, it is in volume 2, it starts from page 219. Volume 2. I start from paragraph 9. What is the stand taken by them? It is at page 21. That with regard to the statements contained, your lordships have found
1 second. Yes, sir. Thank you. 220.
21.
Nine.
Paragraph 9. That with regard to the statements contained in paragraphs 4 to 7 of the injunction application, the answering defendant specifically denies each and every statement contained therein, save and except what are matters of record. The plaintiff has specifically admitted the fact that the property purchased by the plaintiff from the defendant number 6 and 32 do not include the suit property, as already stated above, that the answering defendant is the sole and absolute owner of the suit property. It is specifically denied that the plaintiff approved the answering defendant and requested to transfer the suit property, and it is specifically denied that after several negotiation on oral agreement was entered by and between plaintiff and the defendant number 1 in or about 7th May 2030. The answering defendant states that no negotiation was held by and between the plaintiff and the answering defendant number one, and no oral agreement had been entered into between the parties in or about 7th May 2013 or any other date. The answering defendant number one specifically denies the existence of any oral agreement, and as such, the contents of the said alleged oral agreement is also denied. The answering defendant number one sold some of the properties belonging to the answering defendant in favor of the plaintiff, but such sale was not based on any oral agreement as alleged by the plaintiff. The answering defendant had sold the said property to the plaintiff at consideration amount of 1.46 crore, and with a view to invest the said money, the answering defendant number one had purchased some properties from the plaintiff at a consideration amount of 1.24 crores. That is his explanation to what the difference in the consideration price. That it is specifically denied by the answering respondents that the answering defendant had sold some properties to plaintiff and had purchased property from the plaintiff in terms of the alleged oral agreement dated 7th May 2013. It is denied that the plaintiff had sold properties with the defendant number one in discharge of its reciprocal obligation in terms of the alleged oral agreement dated such and such. Now, I will kindly come to paragraph 11, page 223. With regard to the statements contained in paragraph 9 of the said injunction application, the answering defendant denies and disputes each and every statement contained therein, save and except what are matters of record. The answering defendant specifically denies the contents of the said letter dated 23rd September 2016 and denies that the discussion and negotiation were held between the plaintiff and answering defendant in respect of the properties as contained in the said letter. The said letter dated 23rd September 2016 is an afterthought and unilaterally written by the plaintiff, and the answering defendant never responded to the said letter or accepted the content of the said letter.
You said that it's admitted.
Yes, my submission before your lordship is that the receipt of the letter has not been denied.
All right.
It is accepted. He does not say that I never received these letters. He today
Contents are denied.
Contents are denied when? At the stage of filing this.
Never responded.
Never responded. So he admits that I received the letter, I did not respond to it, and today at the stage of consideration of injunction, I am denying the contents thereof. That's the reason why, Malad, I submitted that there is no contemporaneous denial, despite receipt of this letter. The said letter is an afterthought with a view to grab the property of the answering defendant from the said letter dated 2016. It will be evident that there was no oral agreement dated 7th May 2013 in existence as alleged.
Never responding to it will to existence. Kindly turn over to page 224. Yes.
The 3 lines from the top. Furthermore, from the said letter dated 13/2/2017 and 2/11/2017, it is clear and evident that the plaintiff are requesting the defendant number one to sell the suit property. The answering defendant number one states that the answering defendant number one has never accepted such request nor had responded to such letter. Thus, the contention of the plaintiff that the defendant had failed to discharge the reciprocal obligation in terms of the alleged oral agreement dated 7th May 2013 is baseless and devoid of merit in view of the fact that there was no oral agreement. So, but my letters I have placed before your lordship. I am not troubling your lordship with it again. It specifically says that there is an agreement, these are the terms, and you please comply with it. But what is their answer to it? Their answer is, I got it, I did not respond to it, and now I am saying that I am denying the contents. No contemporaneous data. In my respectful submission, that amounts to acceptance. This is the main stand taken by them, my lord, that there is no relinquishment. That's the only stand taken by them. Now, my lord, ওটা কোথায় আছে? Yes, but he had referred to, your lordship will find it when I take your lordship through the impugned order. But there was an application made jointly by us as also the defender number one for mutation and changing the nature and character of some of the lands. We had to bring it to commercial so that we could develop the land. Now there is a joint declaration which says that your land will remain with you and my land will remain with you. But that declaration, Malad, they have relied upon, and the learned judge has also considered it. But my submission would be it has not been considered in its proper perspective. Before I take your lordship to the judgment, Malad, I place that document before your lordship. But it is at page 232. It is 232 volume 2.
Yes.
It's a part of their written objection, right? It's their first annexure, R1. This is from jointly from the plaintiff and the defendant number one, addressed to the Block Land and Land Reforms Officer Domjut. It is a joint petition on behalf of Olaf Nivas Private Limited and Devashish Pal. Respected sir, Olaf Nivas has purchased around 16.89 acres of land in Domjut district from Mr. Devashish Pal and his other co-sharers. The predecessors of Olaf Nivas Private Limited had acquired title over the property through purchase or through partition deeds, which have been presented by Olaf Nivas Private Limited at the time of mutation hearings. At the time of filing the mutation, Olaf Nivas Private Limited was unaware that Devashish Pal had already got his land mutated post partition and sale, and as such, after mutation of the land purchased by Olaf Nivas in some darks and residual land had been divided in favor of all the co-sharers of Devashish Pal. Then there was the list of the plots. Both the parties are sat together and it has been decided, mutually agreed between them as follows. Plot numbers in which Olaf Nivas Private Limited shall have 100% share. This is the list. Then, Malad, the next page, Roman 2, LR plot numbers to be shared between Olaf Nivas Private Limited and Devashish Pal. These are the plots. Then 3 is plot numbers be shared between Olaf Nivas, Devashish Pal and others. That is a list. Then, Malad, page 234 at the bottom, the area of the other LR plots should be recovered. Should be recorded, recorded in favor of Olaf Nivas Private Limited as per their application and supporting papers, and the residual areas in the plot should remain in the unaffected Khotians or in the Khotians with unsold area. Then, Malad, this last line at page, the first line at page 235 is very important. Kindly mark that LR plots in which Devashish Pal is having 100% share as on date shall remain with him. In view of the above, you are requested to dispose of the petitions of Olaf Nivas Private Limited on the above agreement. So, this was as on that date. This is in 2017. He is yet to sell me land. He has not sold the land. But I could not get these other plots mutated. So at that, as on that date, we filed a joint declaration that this is mine, this is yours. But that doesn't mean that it will remain forever. Now they are interpreting it in this way that you have filed a joint declaration and therefore this is my land, this is your land, and therefore there can be no other question. And unfortunately, one of the learned judge has also considered that in the same line. Now, Malad, kindly now, Malad, come to the impugned judgment and orders. That is in volume 3. Starts at page 300. Volume 3. Order dated 3/10/2019.
Yes.
Kindly skip over the entire facts. I have more or less told your lordship. Kindly come to page 310. $310 from the second paragraph.
Yes.
But the first paragraph is also, I had referred to your lordship. Originally, we had got an injunction which was sent here, then it was set aside and back. So now the findings starts from the second paragraph. From the submissions of the parties, I find that it is an undisputed description of the existing scenario that the plaintiff is willing to purchase a piece of land measuring 151.46 decimal, which has been referred to as suit property from the defendant number 1 since he is absolute owner of the same, and further, according to plaintiff, since the defendant number 1 had orally agreed to sell the said property. From the admitted description of both sides, I again find that from NH6 there is a common passage which is 40 feet wide and leading to the industrial park, which is already under the occupation of the plaintiff, as well as to the suit property under occupation and ownership of the defendant number 1. So he admits that the passage is mine, I am in occupation and he is in occupation of his property. There also I am not disputing. I admit that he is in occupation of his own property. In the injunction application, plaintiff has relied annexure A and annexure B to give details of land measuring 23.89 acres, which according to the plaintiff and the defendant number 1 and defendant number 6 to 32 occupied, and thereafter sold partially to the plaintiff. Along with the injunction application, no schedule of the property has been given. Though there is no specific averment in the injunction application that the plaintiff may be treated as a part of the injunction application, but in paragraph 8, white page 14 of the injunction application, the plaintiff has mentioned that the suit property has been described under the schedule of the claim. Now let me see which properties have been referred under the schedule of the claim as suit property. In page 27 of the claim, the said schedule is given under given where 151.46 decimals of land under different dark numbers, but under LR Khotiar number 918.2 at Mouja Biponnopara, JL number 27, PS Domju District Howrah, have been referred as suit property. As per the schedule, and the common passage has been referred as south and east boundary of the suit property. Therefore, from the reference of the suit property, it is clear that the common passage referred in the schedule and shown in annexure B is not the suit property, but only the reference boundary of the suit property. But kindly mark this portion, it says that it is not the suit property. But kindly pausing here for a moment, kindly consider two aspects of the matter. My suit is for specific performance of sale of that particular land. So therefore, the common passage cannot be the schedule of the property. It has to be the land which I am going to purchase. That is the schedule. But it includes the easementary rights. So therefore, the common passage will come in. I am also saying that the common passage is not the suit property. But at the same time, if there is an obstruction to ingress and egress of the suit property, then what do? I have to refer to the common passage, but that will not make it the suit property. But at the same time, with greatest respect, court cannot say that because you have not made the common passage a part of the suit property, therefore I will not pass any injunction on that. These easementary rights are already there, and it's there in the schedule. That's why I showed your lordship the easementary rights are included in the schedule. Now, moving on. Now, in page 25 and 26 of the injunction application, white para 31A, the plaintiff has prayed for an injunction order restraining the defendant number 1 from restricting free ingress and egress of the ingress and egress of the
Petitioner.
Through the common passage from NH6 to the suit property. Under paragraph 31B, the plaintiff has again prayed restraint order against the defendant number 1 and 2 from creating any nuisance on the common passage leading to the suit property and the plots of the plaintiff, and from parking vehicles on such passage and creating any obstruction in any manner whatsoever on the common passage leading to the suit property and the plots of land of the petitioner. Thus, from the description of the suit property given in the plaint injunction application and annexure B, I find that the plaintiff has prayed for injunction in the form of restraint order on such piece of land, that is the common passage, which is not the suit property, but boundary of the suit property, as so written in the schedule plain and in view of Order 7, Rule 3 of CPC. Therefore, regarding the property which is not subject matter of the said suit as per given description of plaintiff, I am not so convinced to pass any finding or order in respect of any claim on such property. But this, in my respectful submission, this is the first wrong finding. In respect of the suit property, plaintiff has prayed to restrain defendant number 1 and 2 and their main agents and servants from changing the nature and character of the same, making any construction thereof, and restraining them from restricting the plaintiff from free ingress and egress to suit property, which in the light of the above discussion appears to me as prayer for restraining defendants and their main agents, etc., in restricting plaintiff to enter the suit property. The plaintiff has also prayed to restrain the said defendants from alienating, transferring, encumbering, and creating any third-party rights in respect of the suit property. Now, backdrop of all the prayers for restraint order against defendant number 1 and 2 and their men and agents, etc., is based on a claim of the plaintiff that the defendant number 1 had bound himself to the plaintiff by virtue of an oral agreement to sell the suit property measuring about 151.46 decimals, but thereafter did not perform his part, though on the basis of the said oral agreement, the plaintiff performed their part. Be it mentioned here that the defendant number 2 is not the owner of the suit property, but only the developer engaged by the defendant number 1. Before going into the question whether there is any prima facie case on the part performance by plaintiffs in consequence of any oral agreement, or whether there is any incident of non-performance on the part of the defendant number 1, it is most important and indispensable to look into the alleged fact of oral agreement. In the matter of oral agreement, the law of the land is very clear, and in view of section 10 of the Indian Contract Act, all agreements are contracts if they are made with free consent of the parties competent to contract. Nothing herein contained shall affect any law in force in India, and not hereby expressly repeat, by which any contract is required to be made in writing or in the presence of witnesses, or any law relating to registration of documents. So, from the very definition of contract, it is found that oral agreement is otherwise not contrary to provision of law, may be a contract. At this juncture, learned advocate for the plaintiff has referred 2009 to SCC 582 and alleged that the Honorable Apex Court was pleased to hold that even an oral agreement to sale will be valid, but at the same time, in the same finding, it was stated by the Honorable Court that attention of court not drawn to any law applicable in state concerned at the relevant time, which required an agreement of sale to be made in writing or in presence of witnesses or to be registered. Therefore, when the situation is that the said agreement for sale is not touched by the provision of section 10 of the Indian Contract Act, then oral agreement to sale will be valid. Here, in the instant case, the defendant number 1 has raised the question of law as an impediment to oral agreement, referring Article 5D and Article 23 of the Indian Stamp Act, white stamp duty on instruments in West Bengal. Now, from Article 5D and Article 23 of the said stamp duty on instruments in West Bengal, I find the Article 5D speaks about agreement or memorandum of an agreement if related to sale or lease cum sale of immovable property, the proper stamp duty fixed is the same duty as conveyance Article 23 for market value. In the fact alleged by the plaintiff, with reference to the alleged oral agreement, I find no whisper of any story regarding payment of stamp duty. The plaintiff has argued that oral contracts are not required to be registered, and accordingly 5D and Schedule 1A of the Indian Stamp Act has no effect on oral agreement. I am not convinced with the argument of the defendant, since 5D of Schedule 1A of Indian Stamp Act has mentioned about the occasion of agreement if relating to sale of immovable property without mentioning whether such agreement is in writing or oral. Malad, just pausing here for a moment, Malad, we could not convince him about the non-applicability of the Stamp Act to the law of oral agreement, but Malad, we were able to convince your lordship at the time of admission of the appeal, and Malad, your lordship has been pleased to pass an interim order, and I'll come to that later. I'll also place the judgment and the contract act. Therefore, the proviso to section 10 of the Indian Contract Act, though have not referred about any impediment under the provisions of Indian Stamp Act, but in the instant case, no acceptable argument has come before me clarifying the legal sanctity of the alleged oral agreement in view of Stamp Act. So that's the legal point on which injunction was refused. I'll come to that. Now let me go into the prima facie factual indication to presume that there was any oral agreement for sale of the suit property by and between the plaintiff and the defendant number one. The plaintiff has referred about certain mutual obligations which according to plaintiff was completely performed by them and also partially performed by the defendant number one, but not completely. So the cause of action of the suit arose. According to plaintiff, a piece of land measuring 65.640 decimals in several plots within Bipannapara Mouja sold by plaintiff to the defendant number one against the payment of rupees 1.24 crores, and thereafter the defendant number one sold to the plaintiff 6.650 decimals of land in several plots in Mouja Mohiyari against payment of 1.46 crores, and also sold other lands in total 2.3534 acre on execution of 5 several deeds. Here, the plaintiff has argued that in performing such conditional mutual obligation, the defendant number one was agreed to convey the suit property at an agreed consideration of 3 crores 36 lakhs 88,544, and the plaintiff to perform their part towards the mutual obligation provided the defendant number one a concessional price of said 65.640 decimals of land and permitted the user of common passage by the defendant number one. But the defendant number one, after conveyance of 2.3534 acre to the plaintiff, did not perform his part completely by conveying the suit property. Further, according to plaintiff, on 23/9/26, 15/2/2017 and 2/11/17, 3 letters were issued to the defendant number one asking him to perform his part, that is to convey the suit property as per agreed consideration, but the defendant number one did not respond. To access prima facie case, the existence of any such oral agreement between the plaintiff and the defendant number one, I find no other documentary evidence except the said deeds of conveyance executed by defendant number one in favor of the plaintiff on 25/4/2014 and 1/11/2015 White Annexure C, and copy of letters above. Reference from plaintiff to the defendant number one, White Annexures F, G, and H. Beside the above mentioned logic of the plaintiff, that the defendant number one was provided with the concessional rate of land during his purchase and right to ingress and egress on the common passage. Now from Annexure C, I find only a list of deeds, deed number, date, etc., of which vendor was defendant. Vendor was defendant number one, and purchaser was the plaintiff has been given, and naturally I find no option to cultivate whether in the contents of such deed there was any reference about oral agreement stating as such that the parties to the said deeds of conveyance had any such previous oral agreement, and in consequence of such agreement, those deeds of conveyance were executed. In fact, no such fact has been placed in argument by the plaintiff in support of the said oral agreement. But pausing here for a moment, well, I humbly submit this, that this is not a requirement under Section 10 of the Contract Act. There is no requirement that an oral agreement has to be recorded in writing or it has to be referred to in any other document. If that had been there, well, then the Section 10 becomes redundant. Now from Annexure F1, I find that find in the letter 23/9/2016, the plaintiff has appealed to the defendant referring to his commitment, though no date of such commitment has been referred there. The letter dated 15/2/2017 is nothing but a reminder of the letter dated 23/9/26, and the letter dated 2/11/17 is also a reminder of the said two previous letters. Thus, from Annexure F, I find no whisper about the date 7/5/2013, relying and referring which the plaintiff has claimed the existence of oral agreement for sale. Again, Malad, pausing here for a moment, I humbly submit, Malad, that the letter I read out before your lordship, it clearly says that this was the agreement, these were the terms, we have done our term, and we have complied with our terms, and you have failed to do it, please do it. Now, just because I have not mentioned a date on which date we agreed to do that, that would not, Malad, in my respectful submission, render the entire document futile for, Malad, considering prima facie case. It is already stated that the said 5 deeds executed by the defendant number 1 are not referred by plaintiff mentioning any averment of the same as written negotiation of such alleged oral agreement, and subsequently it is found that the letters to the plaintiff to defendant number 1 have also not referred the date of alleged oral agreement. To justify the concessional rate of the land that sold the defendant number 1 or the right of ingress and egress to the common passage that provided to the defendant number 1 were in discharge of obligation or part performance of the plaintiff is not established in reference to averment of any deed of conveyance which are relied by the plaintiff. But I have demonstrated before your lordship that in that deed itself it is there that I have a right of repurchasing the land or first right of purchase at the highest market value, and also, Malad, so far as the common passage is concerned, it specifically mentioned that it's mine, I will permit them to use, I will develop. So that's a wrong finding also, Malad, in my respectful submission. Thus, to support the prima facie case, I find except the facts alleged by the plaintiff, there is no documentary evidence where any least whisper is given about the existence of such oral agreement. So, Malad, what the learned judge is specifically looking for is that there has to be some reference of that oral agreement in a particular document or in a deed. Otherwise, it is invalid. But that, in my respectful submission, is not what Section 10 of the Contract Act contemplates. Another vital reference in favor of the existence of alleged oral agreement is expected from pro forma defendant number 5, since admittedly the said pro forma defendant number 5 is a company which deals with property broking and or trading, and the said company was also the confirming party to the agreements by virtue of which the pro forma defendant numbers 9 to 15 and 6 to 8 entered into agreements for sale with the plaintiff. Question will arise that the said pro forma defendants 9 to 15 and 6 to 8 while entered into agreement for sale, then why the defendant number 1 was not included in the same right at the instance of the pro forma defendant number 5. But pausing here for a moment, this is not a point taken by the defendants. This is, Malad, the learned judge himself has raised this issue. Nobody has argued this issue. This is also not a part of the pleadings in their written objection. He himself asked this question that if you went into agreement with the other pro forma respondents, Why did you not go into that with the defendant number 1? In this context, but to answer that query,
Yes.
to answer that query, Malad, I say that I have already submitted 5 deeds by which I have already purchased a vast amount of land from him.
It was being done phase wise.
It was being done phase wise. And Malad, even their document, it's both our documents, but he has produced it before the court, where it says that these are the lands held by me, these are the lands held by you. There also, it is all done phase wise. Everything is done phase wise. So therefore, why this question that why you entered into an agreement with X, but why not with defendant number 1? Because my case is that we were doing transactions in a phase wise manner. This was the agreement. He stopped at one point. So we were forced to, if he says that why did you not put it into writing, but my answer would be that letter itself is putting it into writing. I am saying that you had agreed, you have done this, I have done this, and now you please do this. That itself is proof. But there you say that because I have not mentioned the date of the oral agreement, it is not believable. When I show the other documents, the deeds that yes, you have already sold me 2 acres of land, then you say that this oral agreement is not mentioned anywhere. In this context, the plaintiff has stated that in the assignment with the said pro forma defendants number 9 and 15 and 6 to 8, the defendant number 1 was not included, and plaintiff approached the defendant number 1 and various negotiations took place between plaintiff and defendant number 1. So the very language of the plain, white paragraph 4, clearly indicates that the defendant number 1 was not a willing party like the other pro forma defendants to come to any agreement with plaintiff. The plaintiff has referred about the prolonged negotiation with defendant number 1 through its representative, but the name and identity of such representative has not been disclosed to bring clarity and reliability of such referred fact as a backdrop or proof of oral agreement. Again, we are pausing here for a moment, but I do not understand whether he is considering prima facie case or he is conducting a trial. But I will prove the in trial, Malad, I will prove who was there, what he heard, what he did. I will prove everything by evidence. Today, Malad, I am to show whether there is a prima facie existence of this agreement, and I am showing it through the all the transactions which have taken place. But he, Malad, insists that what is the date, who is the person, where did you see it, how did you do it. But this, in my respectful submission, will come at the trial stage, not at this stage. It is quite significant that after alleged oral agreement of 7/5/2013, the plaintiff wrote letter by annexure F to the defendant number 1 on 23/9/16. That is after elapse of 3 years or more. Now this time gap is extremely significant to justify the alleged plea of urgency, which is agitated by plaintiff. Be it mentioned here that the plaintiff in page 18, paragraph 18 of the plaint has stated that the terms of the approval of the Department of Micro, Small, Medium Enterprises and Textiles, Government of West Bengal in regard to setting up of an industrial park, the entire project will require to be completed within 2 years from 23/4/2018. But in the entire relied documents, the plaintiff has not given the said project report and any acceptable clarification as to why the plaintiff took legal action against the defendant number 1, but no legal action against the defendant number 1, but awaited for 3 years or more when the project is so urgent. But again, pausing here for a moment, I have shown your lordship that I was negotiating with him. The agreement of 2013 stood revised in 2017. He agreed to do it for 2 years, within 2 years. But I was pressurizing him or requesting him, whatever it may be, to sell the land. And my project The permission from the government is 2018 and within 2 years I have to do it. So it's all a process. And why I ran to court? Because he started construction there. He did Bhumi Puja. That's the reason why I showed your lordship. That's the reason. Otherwise, I would have tried to negotiate and get the property from him. In fact, that is what I was doing. It is already discussed with reference to Annexure F that in the said letter the plaintiff has mentioned you have agreed to sell your landed property. But about the date, place and occasion of such agreement, the plaintiff remained completely silent. When in writing, the plaintiff approached the defendant number 1 to keep his assurance or commitment. I fail to understand whether the plaintiff has interpreted suo moto the alleged agreement as assurance. If so, then mere assurance is not contract. Your lordship, I can take your lordship back to the letter. It specifically says that you have agreed and you have contracted. Both the word agree and contract is there. At the end, I say that you have a commitment, your assurance is there. But he cannot choose and pick two words and say that commitment and assurance when I have also used the words contract and agreement. Therefore, from the materials relied by plaintiff, I find the fact alleged by them is not only confusing and ambiguous, but also not specific and sufficiently clear to hold the prima facie case existence of the same. In that sense, when the prima facie case, when the prima facie case is not clear to justify the prayer of the plaintiff, rather the basis of the same, there it is not possible to extend any equitable relief in the form of temporary injunction in favor of the plaintiff. And in this context, I like to refer Cal 1 Calcutta, it should be Calcutta, it should be CLT, Calcutta Law Times, 1998, Volume 3, High Court 55. Mentioned by the defendant numbers 1 and 2. The said case, the Honorable Court was pleased to hold. Once it is held that the plaintiff did not have any prima facie case, question of passing any order of injunction in his favor did not arise. The court in that situation is not even required to go into the question of balance of convenience and irreparable injury, which it is otherwise bound to do. The plaintiff has repeatedly admitted, as well as it is vital relevant fact to the subject matter of the suit, that defendant number 1 is the absolute owner of the suit property, and without any acceptable prima facie case, if he has been restrained from exercising his civil rights, then the same will obviously cause inconvenience to him, and accordingly, in the light of the above discussion, the balance of convenience and inconvenience is favoring the defendant number 1. In question of irreparable loss and injury, I like to mention page 20, paragraph 21 of the claim, where the plaintiff has claimed themselves entitled to compensation and or loss and or damages caused thereby. The plaintiff has also claimed for a decree for damages to the extent of rupees 120 crores. In this context, I like to mention the observation of the Honorable Court. If loss or injury can be adequately compensated by money, no injunction can be granted. AIR 1976, Allahabad, such and such.
Obviously.
Again, pausing here for a moment, that's an alternative.
You need not pause here.
Very good. From the
This is a strategy will also not be present.
specific performance is now mandatory.
No.
From the above discussion, I find that all the three conditions: 1, the existence of prima facie case; 2, balance of convenience of the parties; and 3, irreparable injury are not in favor of the plaintiff company. Hence, it is ordered that the temporary injunction petition filed by the plaintiff is rejected or contest, but without any order as to cause. Now, Contract Act, your lordship will kindly see section 10, not required.
Yes.
I had placed a judgment for your lordship 2009.
Who is?
Volume 5. But kindly take volume 5 once. I'll just show to your lordship. But the defendant number 2. in our rejoinder to that. But I'm not troubling your lordship with that. We have denied it, and we have said that what we have said is correct, that at that point of time, Malad, they put up a board of this company is known as Midday Construction. They put up a board and signed for Bhumi Puja, and therefore we came to this. And at that stage, Malad, it was at the very nascent stage of the construction, and subsequently, Malad, time has passed. They have made some construction. I cannot deny that. But the fact remains, Malad, as far as we are concerned, Malad, we have made applications one after the other whenever they did something wrong. Can 2 is there, Can 3 is there. The developments were brought before your lordships, Malad. Photographs are there, police complaints are there, everything is there. But Malad, my humble submission before your lordship is that no further construction they should be permitted to do. And Malad, they should not create any third party rights. These are the two prayers that I'm praying. Ingress, Malad, your lordship has already protected us. That, Malad, I would humbly submit that may be confirmed. Malad, the orders that your lordships have passed, Malad, if your lordship kindly goes through, kindly take, Malad, the volume 4. Kindly come to page. We come to Malad, the last annexure, Malad. Page 545.
Yes.
It's an order dated 23rd June 2026. Third letter counsel for the parties, the affidavits in opposition and reply filed in court today be kept on record. From the order dated April 7, 2026, it is seen that this court substantially recorded the moot questions involved in appeal, and being satisfied with the prima facie case was made out for hearing of the appeal on merits, as well as there being continuing cause of action insofar as urgency is concerned. This court has granted injunction. Then a senior counsel appearing for the appellant submits that over and above the injunction already granted, the respondents be restrained from creating any third-party interest in respect of the subject property. Then a counsel appearing for the respondent opposes the prayer for injunction and seeks to avert to the merits of the appeal. Then a counsel also points out that contrary to the arguments made on the earlier occasion, there is nothing on record to indicate that there was an oral agreement between the parties. Moreover, it is argued that none of the subsequent transfer deeds executed by the parties reflect the existence of any oral agreement, nor is any oral agreement specifically mentioned in the correspondence between the parties. Such contentions are controverted by learned senior counsel appearing for the appellant by relying upon annexures to the injunction application. Be that as it may, we have already granted an injunction on the categorical finding that there is a prima facie case made out by an elaborate order, and no change of circumstances has been made out to have been taken place in the meantime. No useful purpose would be served in hearing the injunction application at length akin to the hearing of the appeal. Accordingly, we extend the interim order granted the disposal of the appeal. In addition, both parties shall maintain status quo with regard to creating any encumbrance and or transfer of the suit property and not creating any third party interest in respect of the suit property and also during pendency of the appeal. I was humbly praying that let that be extended till disposal of the suit wallet so that he cannot create any third party interest over that property, because otherwise that would unnecessarily create more litigations into that. And there was one judgment I was referring to, because the learned judge found that there cannot be an oral contract for agreement for sale. It's 2009 volume 2 page 552. 580.
You're wondering how you affix a stamp in an oral agreement.
Exactly. But that is
on the mouth is you may affix it. Or you put in the stamp duty just like
There are incidences where, my lord, letter found to be an oral agreement, letters are stamped.
But
Finally,
that's not an oral agreement. Letters are not found to be
even
oral
plain are being taken to be stamped.
Letters are promises and acceptances, and those letters, the correspondence constitutes the contract.
Absolutely.
That's not an oral agreement. The correspondences themselves constitute the contract. Those are the documents. But in an oral agreement, it has to be your mouth.
But I was thinking in this line when I was getting.
You're right. If correspondences themselves comprise of the contract, then those can.
Those are
Definitely.
missed.
Here, their case is not that correspondences are the contracts. They say correspondences reiterate the contract, which was all.
But I was also thinking in this line while I was getting ready for this matter. I kindly think of it in this way. Any agreement for sale or a sale deed for that matter has to be preceded by an oral contract.
In that
Because,
sense,
Malad,
yes, yes.
it has to
Consensus
be.
ad item has
I have to say that you give me this, I will pay you this amount, you
at
agree.
some point immediately before that there has to
Then
be.
the document is drawn up. And of course, if the document is executed, it has to be
Yes.
registered as
You're
well.
right in that sense.
So in that way, Malad, there has to be an oral contract always preceding a written contract.
Yes.
Otherwise, Malad,
Sans agreement, there cannot be any deed.
they cannot.
True, true.
Malad, paragraph 17 I was referring to. Section 10 of the Act provides, page 587, Malad. Section 10 of the Act provides that all agreements are contracts if they are made by free consent by the parties competent to contract for a lawful consideration and with a lawful object and not expressly declared to be void under the provisions of the Contract Act. The proviso to Section 10 of the Act makes it clear that the section will not apply to contracts which are required to be made in writing or in presence of witnesses or any law relating to registration of documents. Our attention has not been drawn to any law applicable in Bihar at the relevant time, which requires an agreement of sale to be made in writing or in presence of witness or to be registered. Therefore, even an oral agreement to sell is valid. But in my respectful submission, the same situation is there in West Bengal. There is no bar to an oral agreement for sale of immovable property, and therefore, Malad, this is not. I mean, this is covered. The judgment covers, Malad, the present facts and circumstances, and the reference to Stamp Act by the learned judge is, Malad, in my respectful submission, it's a wrong finding. But Stamp Act relates to instruments. But everywhere it is written in the articles, but it's instrument. Once an instrument is prepared, yes, it has to be registered and it has to be stamped. But as long as there is no instrument, Malad, in my respectful submission, Stamp Act does not apply. And this is the judgment I'm relying on. These are the submissions.
Well, his entire case on injunction is there is a subsisting oral agreement. Now, my lord, when he makes out a case of an oral agreement, my lord, my respectful submission is, my lord, it is a case, my lord, which he has to show beyond any presumptive value, but the strongest of the case. Otherwise, my lord, it is unlike an written agreement where there is something on record written. Court is looking at the written agreement, but he is relying upon an oral version which court is not viewing. So one has to bring out a case where court has to somewhat see through the documents on record that there was a prima facie existence of an oral agreement.
And the terms of the oral agreement should also be prima facie visible from those documents.
Visible from those documents, or if I can be a bit lesser side, at least somewhat reflection the parties has agreed to do something in future in respect of that property in question, if not the full terms.
Yes.
So, my lord, in this factual background of the matter, my lord, may I just place the plaint, because his plaint would, my lord, show how he has, my lord, come up before the court by what pleadings. Now, kindly takes up the plaint volume 1 once. Because he has shown, my lord, my written objection is, or written statement is, complete denial of everything. Now, my lord, kindly takes up volume 1, page 10 onwards. Now, my lord, I will referring to paragraph 4. My lord, that is the paragraph. Now, my lord, kindly, the defendant number 5, a company within the meaning of Companies Act and dealing in the property broking and or trading entered into an agreement with pro forma defendant number 6232 to purchase their respective lands, both divided and undivided share. Thereafter, by several agreements, all dated 25th February 2013, Surjokanto Pal, the names are there, being the pro forma defendant number such and such, respectively entered into agreement for sale. Now, pause here for a moment. Kindly marks the date here. It is 25th of February 2013. So, these transactions of purchasing property from Pal family has occurred prior to the oral agreement he alleges.
Yes.
So, it is not something, as he plays the case, that he was phase by phase purchasing the property and dealing and entering into negotiations. So, after purchase of property from the substantial portion from these persons, he alleges now afterwards that he enters into an oral agreement, and in what manner. So, this date would be important. Nominated the plaintiff in its place and state for purchase of such plot of land. The pro forma defendant number 5 was the confirming party to the said agreements. The said agreements and a nomination did not include the holding of the defendant number 1. It transpired from the records that the defendant number 1 was holding substantial land in the said total area of 23.89 acres. Since the plaintiff wanted to acquire the entire area of the land for the purpose of setting up an industrial park, the plaintiff approached the defendant number 1, requesting him to also transfer his holding in the said area scattered in various plots. Various negotiations took place between the said defendant number 1 and the representative of the plaintiff, starting from the month of April 2013, and ultimately an oral agreement was entered into between the parties in or about 7th of May to the following effect.
Yes.
Now, my lord, what are the terms, my lord, what was entered as per him? That the defendant number 1 owns such and such acres of land which is held as an undivided share as well as divided share. That the defendant number 1 shall convey the total area of such and such land to the plaintiff at an agreed consideration of 6 crores and odd. That the partitioned area of 151 decimals of land which is held by the defendant in exclusive area in plot number such and such Moja Biponnopara shall be conveyed by the defendant number 1 in favor of the plaintiff upon the plaintiff performing the following reciprocal obligations. This is important. That the plaintiff would convey to the defendant number 1 65 decimals of land in several plots within Moja Biponnopara district Howrah, which the defendant number 1 shall be entitled to hold as exclusive area, and for which the defendant number 1 would pay to the landlord a sum of rupees 1 crore 24 lakhs as consideration for such transfer. So, my lord, this reciprocal, this is the first obligation, my lord, he has to perform. He has to sell the land to defendant number 1 at the agreed consideration. Upon, second, my lord, upon transfer of said 65 decimals of land, the said defendant number 1 would convey and transfer 65 decimals of land in several plots, both in Moja Mohiyari, totaling 53.99 decimals, demarcated along with undivided unseven share in the different area at Moja Biponnopara and Moja Mohiyari, totaling 11.65 decimals for a consideration of 1 crore 46.
He says that these have been done.
He says this has been done. So, my lord, first he discharges his obligation. Second, I discharge my obligation by selling my portion to him. Now, my lord, these two deeds become very important factor because this is something exchange happening in view of an agreement which alleged to be entered between the parties.
Yes.
It is not an independent transaction which is happening. Now, my lord, if that be so, my lord, these two deeds which were before the learned trial court, my learned senior friend fairly admits that in those two deeds there are no reference to any oral agreement of any manner whatsoever. So, my lord, this view, my lord, of oral something happened prior to, my lord, execution of these deeds. Because this is reciprocal, this is not phase by phase, no more phase by phase. This is reciprocal obligations coming in. So, my lord, he is not purchasing or giving his land in a phased manner.
So you're saying that they are trying to make out an oral agreement
Yes.
in the contours of the deeds which are already there.
Yes.
Deeds were there independently.
Independently,
Transactions
absolutely.
exchanged,
Absolutely.
and around that they try to build this
Build
outline of
this,
this
yes,
oral
oral
agreement.
agreement. Absolutely. That's why,
Working on the
yes,
documents which are already
yes,
there.
that's why the purchase were happening prior to oral agreement. The all families were selling the properties.
All right.
Now, thereafter, my lord, thereafter, my lord, point number 3, upon such mutual transfers of land as aforesaid, the defendant number would convey and transfer 151 decimals of partitioned and demarcated land held by defendant such and such plot in Moja, Bipornopara.
This is the subject matter.
This is the subject matter.
Yes.
So, my lord, first two are the mutual exchanges happening, then, my lord, this would happen. So, my lord, in those two deeds, my lord, if there is no reference to the oral agreement, in my respectful humble submission, it is settled. My lord, this strongest of the case, he has not placed or made out to show there is any existence of any oral agreement. Now, my lord, if it is held that mere pleading in a plaint that this has happened and there is an existence of an agreement, then every case, my lord, even there is nothing in air, not a single scrap of paper before the court, and injunction would be granted on a property which is admittedly owned by a party and who has commercially exploited it.
All right.
Now, my lord, next, it was further agreed. So, agreement will not continue. It was further agreed between the parties that the payment to be made by the defendant number 1 to the plaintiff in respect of said 65.64 decimals of land would be concessional price, considering the fact that the said defendant number 1 would be helping out and cooperating to plaintiff in getting conveyance deed executed from the other family. So, my lord, here I may take it two ways. My lord, the concessional price is one of the thing showing that this was sold at a lesser price. Why? Because I am acting now, if I put it in that way, as a middleman. So, my lord, for acting as a middleman, if it's a concessional price, then that oral agreement saying that for this concessional price, I will be selling 151 decimal doesn't arise.
That might also have been a part of the agreement.
Absolutely. My lord, I take it this paragraph to be independent of the other. So, my lord, his argument was why it was concessional price, because I was taking exchange, and my lord, finally he would have sold that 151 decimals of land.
This also may be in the scheme of the oral agreement.
Maybe. But, my lord, I am taking it.
Look, we'll
Yes.
give a concessional price and you will.
So, my lord, there are two angles: concessional price because of middleman, and concessional price because there was an oral agreement.
No, to be reconciled also. Oral agreement envisages that there will be a concessional price for this purpose.
For this purpose, very well.
Entire thing was agreed.
So, my lord, there is a concessional.
Maybe both.
Maybe both.
Maybe both.
So, my lord, there are two ways to look at it.
Yes.
So, my lord, there cannot be a specific case there is an existence of oral agreement unless those deeds, which are the prima facie mutual exchanges, because conditional, this 151 was a conditional sale on the prior happening of two events.
Which do not evidence any such
evidence of this.
Understood.
Now, my lord, this concessional price, my lord, if my lord takes up the deed, my lord, my learned friend placed it. The page that chilo 56, no?
52.
52, my lord.
Yes.
That was the first condition, my lord. I was the purchaser, he is selling his land.
That was the first of the deeds.
First of the deeds. So, my lord, that was at the concessional price, he says. Now, my lord, 1 crore 24 lakhs kindly takes up, my lord, in this deed, my lord, in my respectful humble submission, there is no reference to the oral agreement. So, he has also could not show, I cannot also show, my lord, before my lord. Now, my lord, kindly takes up the market value of the property, page 69, because we have paid the stamp duty.
Yes.
1 crore 24 lakhs, my lord, at the right hand side market, total market value.
Yes.
My lord, we have purchased it at 1 crore 24 lakhs. Is total market value, my lord, at page 69, right hand side bottom. My lord, 88,000 is there, 88,867. So, my lord, primary figure 1 crore 24 lakhs.
But the law says probably that out of the market value assessed by them, set forth value and the amount actually paid, the higher will be taken as the market value.
Yes.
That's the law.
That's the, for the purpose of stamp duty, my lord, that's the law.
Yes.
Now, my lord, we have, the government has found the highest market value to be 1 crore 24 lakhs.
But that might have been on the basis of your consideration, the consideration agreed upon by you. Set forth value is 75 lakh.
Set for, that's very well, my lord.
Set forth value is 75.
So, my lord,
The law is that if you agree to an amount more than the set forth
yes,
value,
so that will be taken.
that will be taken.
So, my lord, it's agreed between both. This is not a concessional price at least. My lord, if set forth value is 75, it's much more higher, 1 crore 24. So, concession has to come below the concessional government rate. Or, my lord,
concessional price may also be in that concessional vis-a-vis the two agreements, but because the exchange was unequal, they paid more, you paid less. So the explanation for that, or vice versa, whatever.
Yes.
So in comparison with the other deed, that concession, that he's referring to that concession.
That day, there also, my lord will find,
Yes.
I will place that deed. My lord will find it was the market value and the set forth value both are there. My lord, in that case,
the other deed.
So, my lord, it was the total value, my lord, there is nothing on record to show something concession happening.
Understood.
So, if parties agree to a value, then it is an agreement arrived.
Yes. Now we have changed the language of part heard. now we say it will appear as special reasons because we have those part heard markings are the reason for the other benches sitting. So we don't know what will happen tomorrow. So hearing is commenced. Full stop. The matter be listed next on August 27, 2026 under the heading Special Effects Matters. Special Effects is the new part.
New part.